Senate will come to order. Secretary will call the roll.
Alvarado. Bettencourt. Birdwell. Blanco. Campbell. Cook. Creighton. Eckhart. Flores. Gutierrez. Hagenbuch. Hall. Hinojosa of Nueces. Hinojosa of Hidalgo. Hughes. Johnson. Welcome. King. Colcourse. Menendez. Middleton. Miles. Nichols. Parker. Paxton. Perry. Shortner. Sparks. West. Zaffarini.
Quorum is present. Please rise in the gallery and as well as on the floor for the invocation to be delivered by Senator Adam Hinojosa.
Thank you. Please pray with me. Our Heavenly Father, we come to you today with gratitude in our hearts, thankful for the opportunity to serve you through our work here on the Senate floor. And while we know we were all called here to do your work, we know that we understand that we serve millions of Texans throughout our great state. And we don't take that responsibility lightly, Father. So we come to you today asking for your wisdom, for your knowledge, for your understanding. We ask that you grant each and every one of us a discerning heart to distinguish between right and wrong and to govern in accordance to your will. Father, we ask that you surround this Capitol with your legion of angels protecting us, blessing every person who walks through these doors. Also, please keep and protect our families and loved ones who await our safe arrival back home. And Father, most of all, we thank you for the promise you have given us, the salvation through your Son, our Lord and Savior, Jesus Christ. And it is in his name that we pray these things to you today. Amen.
Amen. Thank you, Senator Hinojosa. Dean of Senate moves to dispense with the reading of yesterday's journal. Is there objections? Hearing none, motion is adopted. Members, if everyone could take their seats, Senator Eckhart would like to speak very quickly. Everyone take their seat, please. Senator Eckhart.
Thank you very much for recognizing me. As you all may already know, we had a mass shooting here yesterday in which an individual who has mental illness used a semi-automatic and killed 3 individuals, including a child, at a Target. The individual was quickly apprehended in South Austin. The shooting occurred north of the river at a Target store. So I would ask that you join me in a moment of silence for all those who knew and loved these 3 individuals who are struggling with grief after yet another mass shooting.
God have mercy on those souls. Members, if there's no objection, I'd like to postpone the reading and referral of bills and resolutions until the end of today's calendar. Hearing no objection, it is so ordered. Chair recognizes Senator Huffman for a motion.
Thank you, Mr. President and members. Pursuant to Senate Rule 712A, the printing rule, I move that Senate order Senate Bill 3 not printed. Thank you, Mr. President.
Is there objection? Hearing none. So ordered. Whoops. So
That Senate Bill 3 that you just voted for in Finance not be printed. Okay. It's just,
all right.
all right. Thank you.
Senator West, that button still works on your end. It's a little red button out front. Members, that concludes the morning call. Senator Mendez, for what purpose?
Mr. President, I was sitting down reviewing the maps that we're going to be asked to debate here in a little bit. And I couldn't help but think about the hearing we held in Kerrville about a week and a half ago. So I was going to ask a parliamentary inquiry.
State your inquiry.
Mr. President, is it possible for a member who is not the author of a Senate bill to be able to make a motion to suspend the regular order of business so that we could bring up the flood relief bills to the very top of today's order of business because of the grief and all of the things that we heard in those 13 plus hours of testimony that we heard? And you have a bill, and there are others that are out there. And so I just thought maybe we could hear them all together at the very front end and start this day on a positive note, helping take care of Texans. And so is there a motion, a way that we could do that? That's my parliamentary inquiry.
The order in which we go in is up to the presiding officer.
President, are you not the presiding officer right now?
I would be that guy. I think I'd like to leave this day on a private note.
I'm not understanding your answer, Mr. President.
Your parliamentary inquiry is, can we change the order so we can start out on a positive note? I'd like to end on a positive note today. And I think those bills that you refer to will do that. I hope that the bills prior to that will still do that. They're each serving a purpose.
Mr. President, I just thought that if the bills that you and others have will be able to help provide flood relief, and the bill on the redistricting, all it does is it involves politicians, and so that's why I didn't see how they could.
I appreciate your perspective.
Thank you for answering my parliamentary, Mr. President.
Senator King is recognized for motion to suspend the regular order of businesses on SB 4.
Thank you, Mr. President. Members, I know that There's been a lot of discussion about this bill coming forward today, and everyone has different perspectives on it. I would like to, with your permission though, and patience, there are some things. I know we have a lot of people watching online that haven't been watching the hearings or keeping up with it like we have, and then there's just some things that kind of need to get on the record, so I'd like to take a little bit of time to walk through this to make sure that every member knows how we got to where we are and where I think this is going. And then after that, I'll be happy to answer any questions I can, and I'll just try to answer them as truthfully and as thoroughly as I can. So with that, just by way of where the process to date, I introduced SB4 in our select committee on Monday, August the 4th. SB4 is the companion to HB4, line for line, which passed out of the House committee on August 2nd, 2025. There had been discussions of waiting for the House bill to get here, but just like each of you have done 100 times on different bills, when you have a companion and it stalls in one body, you try to do what you can to get it moving in the other body, which is why I went ahead and filed the companion and began with hearings. As I said, I want to take a moment to discuss the process to date, specifically the public input we've received on SB4 and redistricting in general. First, this plan is based on the 2020 census data, not any annual estimates. Since 2020, the Senate has held 21 regional and other public hearings, and the House has held just as many. Those hearings have afforded the legislature an abundance of opportunities to hear the public's thoughts about the 2020 census data and redistricting as a whole. During this special session, the Senate committee held 4 regional public hearings via virtual testimony, a 5th hearing specifically for invited testimony at the Capitol, and then a 6th hearing at the Capitol for general public testimony. Over the course of the 4 regional hearings, we heard from 205 individual witnesses and had approximately 3,852 clicks to the Senate live stream, meaning that many people, now obviously some of them may have tuned in twice, but we had well over 3,000 obviously watching the live stream. Testimony also included sitting members of Congress. We heard testimony from Mark Vesey, CD 33, Lizzie Fletcher, CD 7, Sylvia Garcia, CD 29, and Al Green in CD 9. On August 6th, as I mentioned, the Senate held a hearing specifically for invited testimony. We invited individuals whose names I had received from the Democrat caucus as their request to be invited to testify. These were organizations such as MALDEF, NAACP, LULAC, and the Asian Americans Advocating Justice, and many others. Senator Miles suggested, at his suggestion, we also invited the entire Democrat congressional delegation to testify as invited for the invited testimony hearing. With the exception of Mr. Bledsoe of NAAC Texas, who attended the following day's public hearing and testified, none of our invitees accepted our invitation to attend our August 6th hearing, which again had been set up specifically for invited testimony. The following day, August 7th, we held a hearing for public testimony. We had 117 witnesses register here at the Capitol, and 42 chose to stay and testify, and then 5 others submitted written testimony. So over the course of these 6 public hearings during just this special session, the committee heard testimony from 200 and 42 witnesses directly. Ultimately, we voted on SB 4, and it was reported out of the Senate Select Committee on Congressional Redistricting with 6 ayes, 1 nay, 1 present not voting, and 1 absent from the vote. Now, if I may, I want to take just a moment now to discuss redistricting history in Texas and principles and legal standards. I believe I'm correct in stating that redistricting has been addressed during special sessions of this legislature dating back to at least 1871 when they took up school districts in special session redistricting. And then in 1882, they took up congressional redistricting in a special session. This history also includes special sessions in the past 6 decennial redistricting cycles of 1971, 1981, 1991, 1997, 2003, 2011, 2013, and most recently in 2021. Now, I say this because this history illustrates that it is not unusual at all for redistricting to occur in a special session. And also to show that the legislature can choose to redistrict at any time, including during special sessions and mid-decade. It's correct to say that states have broad authority recognized by the courts under the U.S. Constitution and its election clause to choose when to do redistricting. Now, for purposes of the map that's before us today, the U.S. Constitution requires that congressional districts be drawn with population as close to equal as possible to achieve the one person, one vote standard. Now, this standard is from the Supreme Court's 1964 decisions in Westbury v. Sanders and Reynolds v. Sims. It's also grounded in the 14th Amendment and Article 1 and 2, Article 1, Section 2 of the Constitution. Because of that, the ideal district size for us today, in terms of this map, is 766,987 persons per district. Senate Bill 4, before you today, meets the one person, one vote standard. Now, beyond this, the area of redistricting law is robust and gets very complex, to say the least. I have consulted with our legal counsel, and I am absolutely confident that SB 4 complies with all applicable law. The House's counsel, it's a different counsel, but they came to the same conclusions. Now, that satisfied my first objective with SB 4, is that the plan that be before you today be legal in every respect, and it is. My second objective with SB 4, first being that it be legal, the second objective was to support a plan that, simply put, elects more Republicans to the U.S. Congress. In contrast to the complications involved with race-based redistricting, this map, SB 4, is built on political performance, which is a well-established and permissible basis for drawing electoral districts as recognized firmly by the Supreme Court of the United States. And let me stress before moving forward any further, this map is based on political performance. Race was not used to draw the map, and I did not consider race when I filed this bill, and I have not looked to any racial criteria with regard to this bill. I have heard the terms packed and cracked in testimony some, but I want you to know that throughout all the hearings we've had, no one has put forth data to support that this map packs or cracks. And honestly, it's difficult for me to see how there can be an intent on my part or anyone's part to pack and crack when race was not even considered in the drafting of this map. So my first objective was that it be a legal map. My second objective was that it perform politically well and elect more Republicans, and I believe there'll be 5 more seats that trend Republican. Excuse me. My third objective, and I wasn't initially intending to focus on this, but we heard repeated comments in public testimony that some of the districts in the existing map that we're under today from 2021, that some of those districts were not compact. We had a lot of testimony meaning that they, suggesting that they were unnecessarily, irregularly shaped, that they weren't compact. But compactness is a traditional redistricting criteria. It helps keep communities of interest together. It makes the district be easier to represent because it's a centralized area. Now, SB 4 accomplishes all 3 of these objectives: that it be legal, that it elect more Republican members to the U.S. Congress, and also now that it be more compact. And again, that is a product simply of the testimony that we heard in the hearings. Now, the impact of this proposed map, at a high level, I can tell you that nearly every one of the 38 Texas congressional districts, nearly every one had their lines changed, but most were in very minor ways. The most significant changes affect 5 districts, and I believe those districts, due to the changes, now lean Republican in performance. Those would be CD 9 in Houston, CD 28 in the RGV, CD 32 in Dallas, CD 34 in Coastal and South Texas, and CD 35 in San Antonio. As I said, it's my understanding that these 5 districts should perform on a partisan basis for the Republican Party. Also, by drawing race blind, SB 4's districts are more compact than the current map, with more reasonable geographic configurations that I think provide a better basis for representation. So in summary, I'll just say that SB 4, as I just said, is more compact than the current plan. And if you want to see a couple of great examples, look at districts 32 and 35 on your desk in the existing map and the new plan. They're great examples of compactness. SB 4 complies with all applicable law. And I will say that we have an excellent law firm. The lead attorney has been practicing redistricting law for over 40 years. And they came through their analysis to the same conclusion that the House did, and others have as well, that the map is legal in respects to all applicable law. We've also had plenty of opportunity to date, really beginning in 2021, with regard to testimony on redistricting and its relation to the 2020 census data we use for this map. But we've also had a lot of testimony, 6 separate hearings just in this special, and no one has presented data or, frankly, any compelling case that this map violates any applicable laws. Beyond that, I would also mention that no amendments were filed that suggested any changes be recommended by the body, Republican or Democrat, for amendments to change this map. And with that, Mr. President, I'm happy to answer any questions.
Dean Safrarini, for what purpose?
Ask a question?
Do you yield?
Absolutely.
Thank you, Mr. President. Chairman King, briefly, we spoke briefly, certainly just before the session convened, did we not?
Yeah, yes.
And I explained to you that I ordinarily ask the fewest questions possible, but because of my strong opposition for this bill, just as I strongly opposed the Congressional Redistricting Plan in 2021, that I was going to ask many, many, many more questions, did I not?
You gave me ample warning.
In fact, Senator, I have a 12-page document of questions that I was prepared to ask you today. But frankly, having understood, because of our discussions earlier this morning, that we will take up redistricting anew in the next special session, I'm going to reserve those questions until next session, so I will not be asking you questions today. Thank you, though, for your courtesy in expecting them. Thank you, Mr. President.
Thank you, Dean. Senator. You good? Senator King moves suspension of regular order of business of SB 4. There is objection. Clerk, call roll.
Alvarado, Bettencourt, Bardwell, Blanco, Campbell, Cook.
In 19 yeas and 2 nays, rules are suspended. Chair lays out on second reading Senate Bill 4. Secretary will read the caption.
Senate Bill 4, relating the composition of the districts for the election of members of the United States House of Representatives from the state of Texas.
Senator King recognized for a motion.
Move passage to engrossment.
Senator King moves passage to engrossment. Is there objection? Hearing none. I'm sorry. Clerk will call roll.
Alvarado, Bettencourt, Bardwell, Blanco, Campbell, Cook.
In 19 yeses, 2 nays, bills passed to engrossment will hold there.
Thank you, Mr. President and members.
Senator King, you're recognized with a motion to suspend the regular.
Thank you, Mr.
Three-day
President. I
rule.
move to suspend the 3-day rule.
Secretary will call the roll.
Alvarado, Bettencourt, Bardwell, Blanco, Campbell.
19 ayes, 2 nays, 9 absent. The rules are suspended. Chair now lays out on second reading. Senate Bill 4. Secretary will read the caption.
Senate Bill 4 relating to the composition of the districts for the election of members of the United States House of Representatives from the state of Texas.
You recognize on passage of engrossment?
I move final passage.
Yes, I'm sorry, Senator Zaffarini, I didn't see your light.
Thank you.
Yes, ma'am. For what purpose?
I make a brief statement in opposition to the bill.
You recognize one.
Thank you, Mr. President. Mr. President and members, just as I reserve my questions for the next special session, when we will take up redistricting anew, I had a 13-page closing statement in opposition of this bill, but again, I will reserve the right to make that statement during the next special session. Thank you, Mr. President.
You have reserved that right, and hopefully we don't have another special session that they show up in the House for a quorum. You recognize on final passage.
Move final passage.
Secretary will call the roll.
Alvarado, Bettencourt, Bardwell, Blanco, Campbell.
19 ayes, 2 nays, 9 absent. The bill is finally passed.
Thank you, Mr. President. Thank you, members.
Senator Hughes recognized for motion to suspend the regular order of business on Senate Bill 16. Secretary, read the caption. You're recognized to suspend the rules.
And the printing rules.
And the printing rules. Wait. She gave me the wrong number. Sorry. It's 6 and not 16. You're recognized to suspend the regular order of business on Senate Bill 6.
Thank you, Mr. President. Members, I move suspension of the regular order of business to take up and consider Senate Bill 6, a topic that we've looked at in the regular session and also in the special session. It's about protecting innocent human life. In Texas, abortion, unless to save the life of the mother, the little baby is protected from abortion. But these pills, poisonous, illegal pills, are being mailed into Texas against the law, harming women, killing little babies, and yes, even killing moms. Senate Bill 6 will do something about that, and I move suspension of the regular order of business.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco.
18 ayes, 10 nays, 1 present not voting. The rules are suspended. Chair now lays out on second reading Senate Bill 6. Secretary, read the caption.
Senate Bill 6, relating to abortion, including civil liability for the manufacture and provision of abortion-inducing drugs.
You're recognized on passage to engrossment.
Mr. President, I move passage to engrossment.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco.
18 ayes, 10 nays, 1 present not voting. The bill passes to engrossment. You're recognized for the constitutional 3-day rule suspension.
That's my motion.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco.
18 ayes, 10 nays, 1 present not voting. The rule is suspended. Chair now lays out in third reading and final passage Senate Bill 6. Secretary, read the caption.
Senate Bill 6, relating to abortion, including civil liability for the manufacture and provision of abortion-inducing drugs.
You're recognized on final passage.
Mr. President, members, Big Pharma is breaking the law, and they are illegally mailing dangerous, poisonous pills that are killing helpless unborn babies and are harming and even killing moms. This has to stop. This bill will do it, and I move final passage.
They're voting no on that. They're in the building.
Members, we had a motion or request for strict enforcement on the 3-day rule. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell.
18 ayes, 2 nays, 1 present not voting, and 9 absent. The 3-day rule is suspended. Chair now lays out on third reading and final passage Senate Bill 6. Secretary, read the caption.
Senate Bill 6, relating to abortion, including civil liability for the manufacture and provision of abortion-inducing drugs.
You're now recognized on final passage.
Mr. President, this bill will save the lives of little unborn babies and the health and even lives of moms in Texas. I move final passage, Senate Bill 6.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco.
18 ayes, 2 noes, 1 present not voting, 9 absent. The bill is finally passed. Senate Bill 6. Thank you.
Thank you, Mr. President. Thank you, Senators.
Senator King, you're recognized to suspend the regular order of business on committee substitute for Senate Bill 14.
Thank you, Mr. President, members. This is the same bill, almost word for word, that we passed out of the Senate in the regular session. It got to the floor in the House session, and just in the last few days had a point of order that they didn't have time to fix, but it did have the votes, I'm convinced, in the House. Right now, there's no consistency among law enforcement agencies regarding what files are made public and what files are not made public. As part of a recommendation from the Sunset Review process last session, TCOL was directed to create standardized policies for the confidentiality and release of peace officer information and department file that was adopted by TCOL to prevent any conflict with current law. I will tell you that it mirrors the requirements that are already in statute for any Chapter 143 civil service cities, and that's all your major cities with the exception of Dallas in the state of Texas, although I do believe Dallas has adopted this too. It's certainly Corpus Christi and all the civil service system cities already use this system. The following documents will be held in an officer's personnel file that will be and these are what is available to the public: substantiated misconduct complaints, that's ones that resulted in disciplinary action, all commendations, congratulations bestowed on an officer, and of course their periodic evaluations of the officer. All other things, including unsubstantiated misconduct complaints against the officer, will be held in their departmental file that are not available in an open records request. So those are still available under any legal process, under lawsuits, for Michael Morton, for Brady purposes, Sandra Bland Act. All these documents are still available. This is just restricting them to kind of a fishing expedition in a open records request. The bill now includes language clarifying that fact, that information within the departmental file will still be disclosed as required anywhere else by law. And of course, that would be a meet and confer agreement, Sandra Bland, Michael Morton Act, any of these disclosure requirements that in a discovery process in civil litigation. This all will ensure that information in the departmental file will still be accessible under all existing law. I move to suspend the Senate's regular order of business to take up and consider SB 14 at this time. I move to also suspend the printing rule.
Senator Eckhart, what purpose?
To ask questions of the author.
Do you yield?
Certainly.
Thank you so much, Senator. And I believe that you have covered this, but I just want to make crystal clear. The provision on the very first page, page 1, line 53 and 54. A department file maintained under this section is subject to disclosure only as required by law. And you laid that out really nicely. I deeply appreciate that. I want to be very specific with regard to meet and confer. Is it your intention that disclosure required under an existing meet and confer agreement is protected by that language in your bill?
Yes.
That's awesome. And also, under the Texas Local Government Code, Chapter 143, meet and confer agreements may modify that chapter. And so is that also an example of law that might be required, that might require disclosure of the departmental personnel file for a meet and confer agreement that comes after this bill's passage?
So, and Austin is a 143 city, and 143 does state that the meet and confer agreements entered into supersede certain areas of the law, and it would also supersede this.
So just to be clear.
So if their current agreement, whatever it says today, would be the law in place. In other words, it would be the directive. What they might negotiate in a future meet and confer agreement could change that. But if it did, it would still fall under 143, and it would still fall completely under the Model Act. So yes, for today, it's not going to change. I'm sorry, I'm kind of thinking out loud. But for today, it's not going to change anything that's in Austin's current meet and confer agreement between the city and the Police Officers Association.
And just to be clear, this provision would not affect meet and confer that currently exists or meet and concur negotiated under 143 after this bill passes.
Yes, that's absolutely correct.
Thank you so much for clarifying that, and I would request that our exchange be reduced to writing.
Any objection to the motion? Hearing none, it'll be reduced to writing.
Very much.
Senator West, what purpose?
Question of the author.
Do you yield?
Certainly.
Thank you, Mr. President. Senator King, how does this bill impact investigations by police civilian review boards and different agencies that cities have that investigate police actions?
So it would not unless, well, no, that's not correct. So I'm assuming every city has its own ordinance, and I'm assuming that, if they have a meet and confer agreement, that it doesn't address this. So if you don't have a meet and confer agreement, then a review committee or something, a civilian review committee or something of that nature would have the same restrictions against it, that it would only have access to the documents in the personnel file, which are, again, are the substantiated misconduct complaints, all the commendations and awards, and the periodic evaluations of the officer. They would not have access to the background investigation they did when they were employing that person, and they wouldn't have access to their home address or those things, and they wouldn't have access to unsubstantiated disciplinary complaints.
Don't they currently have access to all of that?
I'm sorry?
Don't they currently have access to all of that information?
It depends on the city. I think Dallas already has a policy that mirrors what we're passing today. I believe that's the case. They're not a Section 143 local government code civil service city, but I think they've adopted that policy.
And it's your intent to make certain that if they have adopted that policy, that they will continue to be able to implement that policy. Is that correct?
Well, this is going to make the model policy from TCOLE and what is in statute for Section 143, it's going to make it apply to all law enforcement agencies in the state of Texas. So to the extent that Dallas is already doing this, it would stay the same. Where they're not, then they would have to conform to the model policy outlined in this statute.
Here's the language that Dallas is recommending. Notwithstanding any other provision, this section does not restrict disclosure of a department file to government agencies authorized by law to access the file in the performance of their official duties. Let me read that to you again.
Yeah, would you please?
Okay, notwithstanding any other provision, this section does not restrict disclosure of a department file to governmental agencies authorized by law to access the file in the performance of their official duties.
So what was added to this bill is the statement that this statute that would not prohibit release of anything, and we added the words as required by law. And that was to make sure that Michael Morton and Sandra Bland Act and meet and confer agreements, anywhere else in statute that it says you shall release these, we added that language so that this bill would not supersede that existing statute.
Well, I'm trying,
now, what you're reading from, I think, is a city ordinance maybe, or a city policy?
Oh, it's a language that they wanted to make certain, they being the city of Dallas, wanted to make certain was in this particular bill. And what I'd ask you, because frankly I hadn't had the opportunity to review it as I would normally review it, what I'd ask is that you recognize what the city is attempting to do, and to the extent that we're going to have a second session, that we work on perfecting the language to make certain it's consistent with what's going on in major urban areas and doesn't prohibit, or I guess you could say, put in place a procedure or law that would make certain that the city is not able to do their business, because I know that's not your intent. So I look forward to working with you to make certain we have language that's consistent, and also protect our police officers.
Okay, thank you.
Senator Hinojosa Hidalgo, for what purpose?
Well, the Senator yield for questions.
Absolutely.
Do you yield?
Yes.
Thank you, Mr. President. Senator Kinky, we went through this process during the regular session, had lots of testimony for and against, and really some on. But your bill is written, what it does, right now, different police departments have a choice that is made by the city and the police department on whether or not to have a personnel file and a department file separate apart.
So all cities that are not under Section 143 of the local government code, they now have the freedom to do their personnel files however they want to. All the cities such as Corpus Christi that are under Chapter 143, they already follow this process of having a personnel file and a department file, and it mirrors basically what's in the bill.
So your bill would make it uniform throughout the state.
That's basically taking the process that's now in place already for cities like Fort Worth and Wichita Falls and Lubbock and Corpus Christi and Houston, and I think there's a total of 70-something cities, and it just codifies for the whole state what is already the practice in those. And again, this came out of the sunset process requiring TCOL to come up with model legislation. Their group that worked on that basically adopted what was there already for cities like Corpus Christi, made that into the model legislation, asked the legislature to adopt that as statute, and that's what this bill's trying to do.
And the other question I had was you answered when Senator Eckhart asked you about the Borden Act, where any amount or any information could be disclosed only as allowed by law. So I think that question has been answered for me. But my other question has to do with the wording. There were some changes that were made in the wording of the bill, and that is your bill essentially says that there will be two categories of documents included in the newly created department file. Any document relating to a license holder not included in the personnel file. What documents are we talking about?
I think it means everything, and it was really hard to try to word that correctly, but the documents that are in the personnel file, which are available to anybody, they can do an open records request, are the substantiated misconduct complaints, the ones that resulted in disciplinary action, the commendations, congratulations, or awards bestowed on the officer, and all their periodic supervisory evaluations. Anything else is going to be in the department file. Anything else.
But here's the problem. The way the language is written in the Senate Bill 14, by the wording, any document relating to a license holder not included in the personnel file, there really is a very, very broad category of what is not included in the personnel file. Instead of just trying to restrict it to just any complaint, whether in writing or whether any document related to an unfounded, where there was no evidence to the complaint. That would be the way to word this, if I may just suggest that. And it would tighten the language to really focus on the department file, which would have any information on any unfounded complaint filed. Would you agree with that?
Yes, in concept, but I think the problem became is they didn't know what, because there's no consistent policy between departments, law enforcement agencies, other than civil service ones. Nobody knew what other things there might be out there that are in files. And so I think the simpler idea became, let's state specifically what must be held and will be held in the personnel file, and then say that everything else, whatever that could be, is in the department file.
Well, what is that? Anything else?
Means anything other than substantiated misconduct complaints, commendations, and awards, and periodic performance evaluations of the officer. Everything else would be in the department file?
I think, Senator King, there's really a backdoor way of providing broad discretion to police departments to be selective as to what they want to put in the personnel file that should not be, what they want to put in the department file that should not be in the personnel file. I would suggest, and I'm going to offer an amendment, just try to tighten the language. It still accomplishes what you want to accomplish in that any complaint where there's unfounded evidence or it's unfounded and there's no merit to the complaint would be in the department file. That's covered, but I think that the language as written needs to be tightened somewhat. But thank you for answering my questions.
Thank you.
Senator Miles, for what purpose?
Question to the author.
Do you yield?
Yes, sir.
Thank you, Mr. President. Thank you, Senator King. Senator King, you know, I've been working on transparency for officers in this state for the last 19 years, ever since I got into this building, going all the way back to a case in Houston, Texas, of a young man by the name of Chad Holly, who was brutally beaten, a young man who was brutally beaten for breaking into a storage facility. I don't know if you may or may not remember that, but for the last, every year since I've been in this building, I've tried to pass legislation to make it more transparent so that we can get into the heart and to the spirit and to the intent of some of our officers and their bad doings. And before I go on with these questions, let me just say that I understand, like you understand being a former law enforcement, 99% of our officers are damn good officers. You and I have had that conversation. 99% of our officers are damn good officers. But it's that 1% of officers that we are trying to make sure we have eyes on and have the right laws in place, because you and I have both agreed that 1% what we in the force call turd officers are just bad officers. Would you agree with me? We had that conversation before and we agree?
Yes, we have.
Sir, again?
Yes, we have had that conversation.
Okay. And would you agree with me that 99% of our officers are fantastic officers and just that 1% is what we're trying to look after here?
I think the percentage of good officers would even be much higher.
Thank you. So Senator King, I have concern about this bill. You know, it could limit the access of important information about police conduct. Transparency is key to accountability, and restricting what is disclosed may reduce trust and make it harder for the public to stay informed. This raises several important questions, Senator King. The substitute to this bill says certain letters and memos and documents in a license holder's department file are subject to public disclosure as required by law. Is that correct?
That is correct.
Senator King, I have a few questions here, so let me get started. You know, Senator King, is it possible that this bill would limit transparency for people requesting access for information about police misconduct? Could it be possible that we're going to limit the transparency?
If it is a random, and by random I don't mean not important, but if it is a random open records request, freedom of information request, that is just by the general public about an officer, then they would be restricted in that access to what was in the personnel file. If it's involved in a lawsuit against the city, a lawsuit against the officer, if it's involved in a criminal investigation against the officer, if it's anything to do with any criminal prosecution of a third party that the officer is a witness in or involved in, all of that officer's entire file would be available. It would only be for those media or individual open records requests that would be limited.
So then you said that it would be limited. So the answer to my question is yes, it could limit transparency to an officer's file.
It would limit access to an officer's file.
It would limit transparency to an officer's file and access. So yes, to that question. What happens if the officer Ramirez transfers from Austin PD to Houston PD? Will past records from that department file in Austin be disclosed?
Great question. Not only is it a good practice, what we don't want is a bad officer, and we've had that trouble with teachers too in the past. You had one school district just releasing an employee, one police department releasing an employee, and it typically happens when they've got a complaint and they're saying, look, we're going to terminate you over this, but if you'll just resign. We know that's how it happens. It's not good practice, but it does occasionally happen. And then they go to another department. But based on legislation that's been put in place in the last couple of sessions, anytime an officer leaves a department, their full file is made available to TICO. And anytime another agency is looking at employing someone who has been previously employed in law enforcement in Texas, that new agency is required to get the entire file from the previous agency or agencies and review that file, and it has to be made available to them. So there's no more passing of a bad officer to another law enforcement agency, because that law enforcement agency by law is required to look at their file from prior places of employment.
Well, I'm going to commend you on that element of this bill, because that has been a problem in the past. As you and I know, it's in law enforcement, when you get in a little trouble in one department, you jump to another one real quick, and that file, they never know of the incidents that happen. So I want to commend you on that element of the bill. But what happens if an Officer Smith is seen by a Pearland police officer, or seen by anybody, a Pearland officer is seen tasing a citizen for jaywalking? Stay with me. For jaywalking, which never leads to a charge, and this incident is placed in a department file. Can that incident be disclosed, Mr. Senator King?
So the only
Not in this file, but people have seen it and they've reported it.
If there was a criminal investigation or a lawsuit or a criminal prosecution of a third party that this officer is involved in, then it would be fully disclosed to the parties involved.
So if there wasn't a criminal...
if it was an unsubstantiated...
Right.
or still under investigation complaint, it would not be subject to the Open Records Act.
That raises the hair on the back of my neck, Senator King. If an officer resigns before an investigation is complete, will any resulting information that later gets an added department file, that gets added to the department file, will it be accessible to the public? You understand what I'm saying? If an officer resigns before the investigation was complete, so he just says, forget it, I quit. Well, the resulting information that later, once you investigate and you later find out that he was guilty and he's no longer on the department, would that information be accessible?
Yes.
In what way?
Well, they would no longer be a part of the department, but it's accessible under the... I believe I'm correct in saying this. If you give me 30 seconds, I'll verify it. You give me 30 seconds, because I want to answer you correctly.
Absolutely, sir. Thank you.
Were you finished on questions? I did not know. Were you finished on questions? Okay.
And I want to answer you correctly, Senator. So,
and I appreciate that, Senator.
Okay, if your hypothetical was an officer's under investigation for some complaint, they just quit the agency and walk away.
Correct.
The investigation is never completed, therefore there was no disciplinary action. Would that information go into their personnel file and be subject to open record? It would not.
One correction.
However, if they were going to a new agency and applying for employment, that information would be completely available to that employing agency.
One correction. The officer resigned and the investigation was completed and they found something. Would it go into that officer's jacket then?
Only if there had been disciplinary action taken against the officer while they were still employed.
But he's not employed anymore. You understand the problem there? You understand the gap we got there?
I understand those things can happen, and
they have happened.
It's it's virtually impossible to legislate for every contingency, but that is theoretically something that could occur.
And it does, as you and I know, it does. So that's not, we didn't solve that problem in this bill. What happens if the officer is involved in a shooting during a traffic stop and the related records are placed in a department file, while the victim's families, will the victim family be able to access those files? Will the victim's family have access to those files?
In your hypothetical, with there being a wrongful death claim there, I'm sure there's going to be a lawsuit or criminal prosecution. Those are going to be available to the family in a lawsuit. They're going to be available to the prosecutors if there's a prosecution, to the defense attorneys.
But so many times, Senator, before a family files a lawsuit, they want to really know what happened, so they request the file before they even want to, so they can know if they should even pursue a lawsuit. Will the family have access to the file before a lawsuit's been filed?
But again, what you're describing is something, also as long as there's an ongoing investigation into that act, the criminal act that led to the shooting and whatever misconduct is alleged against the officer, as long as there's a live criminal investigation going on, nothing's going to be available for release to the family or anyone else.
Well, I'm not going to totally agree, because it happens all the time that an incident happens and a family would like to see the file prior to even knowing if they want to file a lawsuit or not. That's common. That's common. Could this bill limit independent investigators' access relevant to officers' information by restricting public disclosure or department file? Of the file?
I'm sorry, could you say it one more time?
Could this bill limit independent investigators? So basically, a family that wants to know should they file a lawsuit, they hire an independent investigator before filing a lawsuit. Would he have access to this file, he or she?
He would have access to the personnel file only, and it would have all substantiated misconduct complaints, commendations, congratulations, and periodic evaluations of the officer. That would be the only thing that they could get through an open records request.
Okay, what about media? Could media request it under the Public Information Act?
Media is viewed as a member of the public, and that's all they would have access to.
Okay. What safeguards are in place to ensure agencies do not overuse public disclosure rule without information, withholding information? You understand what I'm asking?
Not completely.
Okay. What safeguards are in place to ensure that agencies do not overuse the public disclosure rule to withhold information? Some agencies don't want their officers, the acts of their officers out there.
The same things that are in place today to enforce open records requests.
So this act wouldn't change anything?
Doesn't change anything in the enforceability of the current Open Records Act in Texas.
Thank you. And let me jump down to relating to license holders. The committee substitute requires documents relating to license holders, not in personnel files, be held within the department files. Is that correct?
So the only thing that will be in the personnel file will be those three things I've mentioned. Everything else regarding the officer will be in the department file.
So your committee substitute requires documents related to license holders not be in personnel files, but withheld in department files. Is that still correct?
So when you say documents related to a license holder, what are you referring to?
Their T-close license, maybe, where they got their T-close from.
So, yes, but a lot of that is also available through TCOLE.
Okay. All right, so the last question. How will the department determine what information does and does not is not related to license holders? Well, how will the department determine what information does and does not relate to license holders?
Well, again, I think the wording, I think the model policy that's reflected in this bill tried to be very simple to where it was very clear to any agency and to the public the three things that would be in the personnel file, and then simply saying everything else is in the department file. And the three things are very simple. If you've had substantiated disciplinary action taken against you, if you've had, which would be anything, a written reprimand, a days off without pay, anything of that nature, if you've had, and then all your commendations and congratulatory letters and things of that nature, and then also your periodic evaluations that are done by your supervisor. And for example, I know in the 143 cities we talked about, I believe those have to be done every 6 months.
Senator King, once again, it's bewildering to me that we will be going backwards in 2025 as it relates to transparency when it comes to law enforcement. We've made so many advances forward to opening up and being transparent with everything that's gone on across this globe as it relates to police brutality, as it relates to wrongful deaths. And it seems like we're with this piece of legislation, Senator King, with all due respect, sir, we're moving backwards. We're trying to close the openness that we worked so hard to get to. And from one law enforcement to another, I think that's dangerous. We as law enforcement are public servants, and we work for the people. And you and I have agreed that 99% or higher than our law enforcement are great officers. But it's just that 1% that take the power too far. And we should always, always, always be as transparent as we possibly can when it comes to law enforcement. And because it's a very important job. They have a very hard job. And we just had so many incidents over the years, and it just feels like this bill is taking us backwards, Mr. King. Okay.
And I understand, when you really peel all the layers away, this is the core thing that you're concerned about is that unsubstantiated complaints against the officer would not be available through a normal open records process. And I think the best response I have to that is this. When I was a young police officer, the very first training officer I had assigned to me, he said, "Son, let me tell you, you never get fired around here for doing too little. You get fired for doing too much." And the fact of the matter is that your best officers, the ones that are working the hardest, that are not just trying to pick up a paycheck, they do end up getting more complaints filed on them. And often that is because the people they arrest will file complaints as a way of fighting back against the charges that are going to be out there. Oh, if I can show this officer violated my rights in one way or another, then that'll help push my case to being dismissed. I can remember one occasion when I was sent to a group, and I sat down and told my sergeant, I said, "I'm happy to go do that, but I know I'm going to get complained on because those are prominent folks." And I remember telling him, "I'll do this, but I want your word ahead of time that you're going to back me up when those complaints come in." And so those are the type of complaints that officers, and I agree with them, they believe are not fair to be put into their file and available and to be used to defame them professionally and personally before the public off a simple open records request. So all they're saying, and all I believe this does, is says, if you discipline me, fair enough, that information is available to the public. But if it's just an allegation that any random drug addict could have made, or any upset person I've arrested, or any prominent person I've arrested, just an allegation should not be made available to the public, to my family, to the people I run with. It should not be used to defame me personally or professionally. And I think that's the middle ground this statute's trying to hit.
You get no argument out of me, Senator King, on random allegations. You get no argument out of me, okay? But the intentional bad actors, this bill can help protect. Thank you, Mr. Senator King.
Thank you.
You have a motion to suspend the regular printing order and the suspension. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell.
19 ayes, 9 nays, 2 absent. The rules are suspended. Chair lays out on second reading. Committee substitute for Senate Bill 14. Secretary, read the caption.
Committee substitute Senate Bill 14, relating to certain files maintained by a law enforcement agency regarding certain employees of the agency.
Members, we have an amendment. Secretary, read the amendment.
Floor amendment number 1 by Hinojosa of Hidalgo.
Senator Hinojosa, on your amendment.
Thank you, Mr. President. Members, this amendment I discussed with Senator King. And Senator King, during the regular session, I voted for this bill. And as we discussed during the presentation of the bill, my main concern is that anything in the personnel file can be put in the department file. And to me, that's very restrictive. The department file, the whole purpose of the department file is to protect our police officers from unfounded complaints, where there are allegations. And I understand that. And we'll just leave it to that objective, to that goal. And that is that only the department file should be only for complaints that are unfounded. And the way the bill is written, when you talk about any other document not found in personnel file, goes to the department file. And that's a really backdoor way that I don't think that is too broad in a sense, and just keep it to all the allegations that are unfounded, and it would really tighten the language. And with that, I would move adoption, Mr. President.
Senator King.
And thank you, Senator. I understand what you're trying to do, and I really appreciate the fact that during the regular session, we had great talks about this and worked together on it. I think the way your amendment is worded, it would open up too much. For example, it would expose simple coaching. If a supervisor sat down to have a talk and now they reduce everything to writing, even just coaching, I'd like for you to do this differently next time. Those things would come into that officer's public file, but also their background investigation. And your background investigation is pretty personal. Not only does it have your credit history and your educational history and all of that, but it also has your family members' names. It has all your scores on all your tests, just everything you can think of, as well as all the reference letters and everything. And I think this would open that to being placed in that department file. And again, I think the amendment would just be too broad. So with that, I would oppose the amendment.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell.
9 ayes and 19 nays. The amendment fails. Senator King, you recognize passage to engrossment.
Move passage to engrossment.
Secretary will call the roll when ready.
Alvarado, Bettencourt, Birdwell, Blanco.
18 ayes, 10 nays, 2 absent. Bill passes to engrossment. We'll hold there.
Thank you, members.
Senator Perry, I can't see you through a cluster of senators there. Senator Bettencourt, yes. Senator Flores.
This
Senator
area draws a
Middleton.
crowd. I don't know what it is, this little pocket right here.
They're always standing, they're always talking.
Yeah.
You're recognized. Suspend the regular order of business on committee substitute for Senate Bill 1.
Thank you, Mr. President and members. Senate Bill 1 is the Natural Disaster Omnibus Bill. As you know, our state suffered historic flooding in Central Texas and West Texas last month, tragic loss of 138 lives. In the aftermath, the Senate and House formed select committees to ascertain the facts of the disaster and identify policy solutions that will prevent loss of life due to flash flooding and other natural disasters in the future. Last month, our committee convened 2 joint hearings with our counterparts in the House. It took approximately 26 hours of invited testimony and public testimony over 80 witnesses. We convened our second joint hearing at the epicenter of the disaster in Kirk County, where many of us saw the devastation firsthand. Senate Bill 1 is primary product of the work performed in the last few weeks. The bill is comprehensive, omnibus legislation that addresses many of the concerns that were brought to the committee's attention after July 4th floods. To improve campground safety in summer camps, RV parks, provide emergency rooftop access, summer camps, RV parks will have an amendment that will correct some of this. Provide emergency rooftop access in cabins located in a 100-year floodplain. Adopt flash flood evacuations for all portions of the campground located within the 100-year floodplain. Activate flash flood evacuation plans when a flash flood warning is issued. Provide copies of the plan to local emergency management officials, and in the case of UCAMs, to DISHs. The entire continuity of government in an emergency situation, SB1 creates lines of succession for county judge mayors only with respect to the emergency management responsibilities in the Chapter 418 of Government Code. It also requires specific licensing and better training and drills to be performed once a year with TDM supervision. Additionally, the bill requires TDM and DISHs to develop a mass rapid response team that can be deployed quickly in the event of a mass fatality event. Better position TDM to deal with natural disasters. SB1 requires TDM to develop a volunteer management system that incorporates background checks on those volunteers. Likewise, the bills requires TDM and others to neutralize drones operating over disaster to better facilitate recovery from natural disaster. SB1 expands existing natural disaster loan recovery programs to include micro and small business up to 20 employees to serve small businesses with up to 100 employees. Perhaps the most ambitious SB1 is designed to improve our state's ability to monitor for and predict flooding and other severe weather events by creating a working group of universities and state agencies tasked with developing a single statewide data hub for state flood gauge and mesonet systems, identify areas that lack adequate flood gauge and weather radar coverage, issuing statewide implementation plans. Overall, SB1 is going to be used for all natural disasters. It establishes the backbone of disaster relief, recovery, and preparedness to be established at the local level, to have those responsibilities clear and defined pre-disaster, and have those individuals trained in a way that when those events occur, there's no guessing as who's doing what or what needs to be done. With that, I move to suspend the regular order of business of committee substitute to Senate Bill 1.
Senator Menendez, what purpose?
Mr. President, questions of the author, Mr. President.
Do you yield?
I yield.
Thank you, Mr. President. Thank you, Senator Perry. Senator Perry, first of all, thank you for the hours and hours of work you've put in on this legislation. And I remember in the last committee, you were saying if you had thought this bill would have so much of the justice of the peace, you would have been shocked if someone had told you. And so I do have a few questions because I think some people don't understand exactly what you were trying to accomplish.
And there will be an amendment that cleans that up that will focus purely on autopsies and not inquest.
Okay.
That was worked through with the JPs themselves.
Well, I'm glad to hear that. That was a section of my questions, so I'm going to reserve those till that amendment comes up. And because there were some concerns on who and when an autopsy has to be.
The amendment should clarify that, and that's something that they worked together to make sure we threaded that needle.
I appreciate that. That's very good. On Section 8, on how was the order of priority established for determining emergency management director, will urban counties who already have an established order of command, are they going to have to adjust themselves to this new Section 8 order of command?
I would say yes. I would assume that they're pretty close to that anyway. By statute, 418 was kind of clear in a lot of ways and unclear in some, but it was kind of already out there as a frame for it. So they will need to establish that hierarchy of elected officials. The heart of that issue is we want an elected official that are accountable to the voters to be responsible for the start of this disaster. That doesn't mean they're the emergency management coordinator. That's the person that would designate that person below. So you'll have an operations guy, but somebody needs to be leadership role.
I agree. I'm going to, as this process goes on, I'd like to talk to them about what we can do to sort of coordinate between your Section 8 of your bill and where their issues are. I know they preferred their order of command. In regard to volunteers, there was a lot of conversation about volunteers. There's a concern that we might make it more difficult for folks.
We also have an amendment that cleans that up pretty clearly. I should have went through the amendment. There's going to be an omnibus amendment that does 6 things. First, the JP's exceptions to let them focus on autopsies and not full inquest. The counties and cities to adopt separate lines of succession the bill creates for emergency management directors. It requires the cities to do that. Third, creates an exception for an annual drill. So in this, going forward, you not only have to have a plan, you actually have to have a 1-year annual drill with TDM supervision. Good. If you have had an emergency or disaster within that year, it doesn't make sense to go through the drill. You've had a real drill, right? Good. And the fourth one focuses on the term spontaneous volunteers, and it gives basic exemptions to VOADs and COADs, and only requires those spontaneous individuals to be registered with TDM.
That sounds like that covers some of my questions.
So Red Cross, Texas Baptist Ministry, those groups would not be running through that process.
Very good, very good. So question that I guess, and maybe the one question that I think you stated this in committee, I just want to verify. Volunteers will not be asked to pay for their own background check, right?
No, the section that referred to a fee was for your emergency management coordinators positions.
I remember now.
Those are no different than sheriffs, no different than current process of a 72-hour FBI check. There is a cost to that.
I do recall that. How about under the Small and Micro Business Recovery Fund? I know that small businesses that apply for the loans have to be paid in full of any previous loan they received under the loan program. I believe that's correct.
That is correct.
Okay. So I guess there's a concern for an ability to reach financial stability, and that's one area where I don't know if there's any area to sort of improve or work with these folks, because maybe they had a loan under a different program and now they've been wiped out. I don't know if there's any.
Yeah, I think the way I read that section is similar to what federal disaster loans are, and layering of them is a tough thing to do. I think that this is meant to be a bridge to get you whole. Hopefully you don't have another disaster in the middle. Okay. But that's more of a local banking, right? We kind of underwrite the local banking in this process. So those are probably going to be more banking regs than they are actual statute.
Do we need this legislation to start helping businesses today in these disaster areas? Is there any way that we could do it?
Well, you already have the micro loan in place. We just kind of broadened who can take it. So that's out there. I don't know what the funding looks like or who the banks that are signed up for it.
Okay.
As far as ongoing efforts, your FEMA monies will start filtering through probably in the next 12 months.
Yeah.
The typical things that people think about as historically has been, it takes them 6 months to a year to kind of get that money flowing. They've already given like $23 million to some of the individual assistance.
Right.
But you scattered that over the number of people, it's not a whole lot of money to the individuals. But we just approved $200 million to match the 25% requirement coming out of SB3 today in finance, and that money will be used to match to get the PA public assistance stuff. I think there was some damage to their plant and sewer treatment there in Kerrville. So some of those initial, I don't know that they've had funding. There will be funding coming from the state to do that.
I've just got 2 last questions. They have to do with the communications plan. So I want to know if there are any strategies provided to ensure the communication during a mass fatality event. And then the last question is, can we share in the bill, I couldn't find a definition for a mass fatality event. Do you have that, or is there somewhere else in code?
I don't know that I've defined it specifically. You raise a good point. I don't know what mass fatality is, and I don't know if that's a legal term or a statute term at federal level. We can look at that and clear that up for it. Probably wouldn't be a bad idea, but I would assume, any more than just a few, just a very, very small number. But we had 3 shot here yesterday. Is that a mass fatality? Anything more than one depends on perspective, right? As far as the other question you had, communication, that is being handled out of the House. They're working through it. I triage. So I broke down this event as triage, intermediate, and long-term. So there were some things talked about in Finance Day that definitely fit in the intermediate and specifically long-term with respect to buyouts and those kind of conversations around flooding. And our flood infrastructure fund is intact, and that's really what it's geared toward, is that long-term and possibly some of the intermediate stuff. We separately funded it today under SB 3 for the immediate stuff. The triage is what I call it. Things that we can do today. Right. The sirens, the gauges. Those are things we can start on today. Supply chains and things may make them an intermediate, but we're working on those. So to your question, there are things that in this bill in SB 1 that if implemented today, if we had another flooding event in the same area, the same magnitude, with what this SB 1 will require you to do specifically to camps, you are to move to higher ground at a flash flood warning, period.
End of story.
You don't get an option. So if you're in the 100-year floodplain and you're responsible for people, then basically you got to take heed. You have a responsibility at that point to shelter higher ground. So today, with really minimal money, if no money, just by sheer policy requirement by statute, if you had another flooding event today and you implemented that policy, odds are you would have no fatalities. So there are things that are going to save lives today. We're coming into hurricane season.
Yeah.
That once this is implemented, specifically in the camp areas.
Right.
And I think, I'm just going to say, I think now that we've taken the provided cover, for lack of a better term, very few judges or mayors want to evac. They don't want to send that notice out to their communities. But if they've got the most vulnerable covered in that, and they've got a little bit of kind of a check that, maybe it's bad enough that the rest of the community needs to have a conversation. And I had a very responsible county judge. He evac'd very, very strategically in his county. There were areas he knew for a fact that when the creek beds are running, they probably need to do something. He was very deliberate in that. So I'm thinking SB 1 may give some locals, and county judge didn't have any pushback. It's kind of like, finally, I have an objective standard that I can point to that says they said to do it, and it takes the heat off them. So we don't want a bunch of false alarms, but when you're in that 100-year floodplain and you have a history of that area specifically, and you're responsible especially for kids, you will move to higher ground, maybe an evac or just a different designated place. So it will save lives today, and it didn't cost a dime to do it.
You reminded me when you just said the kids in the camps. I had heard or read that one of the camps requested a waiver to keep a bunkhouse for young children in the floodway. Does this bill address at all?
I think requiring at flood warning level, stage 2, you move to higher ground. And it will be drilled and pre-planned in designated area. And at all costs, if you didn't get that memo or you couldn't do it, you will have access to rooftops. And in the final, my focus after seeing Mystic and walking through that area, you could just look and said, had they been able to, and the water lines were not up to roof lines. So there was a whole lot of opportunity to have that conversation in my mind. And so I don't know about a specific waiver, but I can tell you 150 parks, multiple waivers granted over the decades for different issues and different things. I would probably suggest, yes, there was probably people that had waivers from dishes not, to build inside of a floodway.
I just worry about minors. Like you talked about earlier in committee, if you're a campground owner, if you're a private property owner and you want to build something on your own private property, you make an adult decision, that's one thing. But when we let their kids think they're going to a camp that's going to take care of them, and then they're sleeping somewhere. That to me sounds like a much higher hurdle. So I'm concerned about that, but I'll listen.
Well, I hope that the general areas that are affected by floodplains and may not be directly in one, but know there's a history of problems, that they'll take the flash flood warning to heart and have a pre-designated place and move people to it. I mean, you're never going to stop floods. You have a window of time to respond from flood warning to emergency when it's too late.
Right.
When the emergency sounds, you're pretty much done. Average around 3 hours, I'm told from the weather folks. It may be an hour, it may be 3, it may be it never happened. But we're going to err on the side of caution going forward in these areas that have this history.
I hear you, and I won't beat this horse, but you've seen my granddaughter, my 5-year-old granddaughter, and she's a tiny little thing, and my fear is even if she's 8 or 9, she's still going to be tiny. And she may not be able to do real well on that ladder or on that rooftop.
Yeah.
And that's a concern.
And that's why at flood warning, she should be moved to higher ground without having to worry about climbing the ladder.
Thank you for answering my questions.
Thank you, Senator Menendez. And by the way, Senator Menendez, thank you for your service on the committee. I think the joint committee with the House, the 18 of you, 9 senators, 9 representatives, bipartisan, did an incredible job. I thought the hearing in Kerrville was incredible. And we had to have those hearings, I think, and you had a hearing before that brought so much information forward, which is so important for this bill that I think will pass unanimously. I just haven't had a chance to thank you and all the members that served on the flooding committee. It was great work, Mr. Chairman, and Ken King on the other side is your co-chair, and all the members of the House, and that was very informative. I know I was there for about 6 hours of hearing, and it was excellent work, so thank you. Senator Eckhart, you're recognized. For what purpose?
To ask questions of the author, and thank you very much for recognizing me.
Yes. Do you yield, Senator Perry?
I yield.
Thank you so much, Senator Perry, and particularly for the really substantive and helpful conversations throughout this process. I deeply appreciate that. And I also very much appreciate you incorporating some of the suggestions that we discussed. I have found in this chamber has taught me that you can get a lot more done if you don't need your name on something. This bill is a good bill, and I really appreciate the back and forth between you and Senator Menendez. We had discussed the issue of liability and the concern that some are able to operate businesses either because those businesses are grandfathered or because the businesses purport to be mobile or temporary, and thereby take advantage of cheap but beautiful riverine areas and export the risk onto their patrons. Is there a consideration for continuing to work on that issue, perhaps in the next special, to add some appropriate pushing of the risk back onto the business owners?
So specifically in RV parks, Senator Flores is going to have an amendment, and it was actually a bill, I think, in the last session that didn't get through the hopper, but it effectively, RVs present a little bit of a challenge. They are a commercial enterprise typically. They do have people on site that they've paid to stay there, but they're also adults with fifth wheels and hookers, hook it up and move, right? So that presents a challenge for an owner of a park. They might not even be on site, right? They just maybe have a gate and you pay your fee online and you show up and you get the gate code, whatever. So his bill effectively says you have to have an evac plan on site with a local official, be it county or city. And I think that's appropriate, and as you go into that, you should have that presented to you as a way out. So RVs are a little bit of a different animal. I would hope that people find themselves in those floodplain areas would be aware that they may have to exit quickly and leave their belongings behind. But that's one way we've done kind of the RV. It was actually something that should have passed last session. On the liability on the campsites, we chose not to go to the civil code for a lot of different reasons today, politically. most of them. You know, you get a lot of pushback when you start doing cause of actions. I don't know that I'm for or against that. We can have that conversation as this thing moves forward in the next session, probably. I think that when you have a statutory requirement and you choose not to do that, you can say with certainty would have saved lives, that they've just extended the liability to pretty much out there with the Trial Lawyers Association to having fair game. So there is an inherent liability that they're assuming by not doing what we're asking them to do. And Senator Colcourse has a lot more comprehensive camp owners revision, Senate Bill 60, kind of scaled down a little bit. So it's going to put some more things on the plate of camp owners to be responsible. So all that to say is this one does not have specific civil liability attachment to them, but HERS bills will, I think, depending on the offense and dishes, inspections and things, you could end up losing the licensure out of it. So we're moving in that direction, but at the end of the day, you don't do these things that we've asked you to do and another event comes up like what we had. I don't think it's going to be a tall order to be sued out of existence.
I appreciate your answer, and I also appreciate the difficulty. I also appreciate Senator Colcourt's bill and Senator Zaffarini's bill that are fairly detailed with regard to campground requirements, agreeing with you that that would be some evidence if they fail to meet those requirements in any kind of liability action. Also, we had a lot of really good substantive conversations about FEMA's National Incident Management training and its 5 phases of emergency management. The 5 phases are to plan, then it's to avoid, to mitigate, to prepare, to respond, and to recover. Most of this bill, for all kinds of important reasons, it really concentrates on the last 3, the preparation, the response, and recovery. I did note that the December 2024 Texas Flood Plan concentrates predominantly on the first 2, which is avoidance and mitigation. Do you think that we could work in this second special session, perhaps building on this bill, building in some avoidance and mitigation in those legislative recommendations that are in the 2024 Texas Flood Plan?
You know, subject to the call to start with is what's on it. I'm always open for improving the opportunities to save people and respond after a tragic event. So I'm not going to say no, but I don't know what those look like. The flood plan was extremely detailed and is watershed based, as it always should have been, but never was. This initiative with the new technologies that exist, that we built the advisory group to put those together and funded them this morning, is still watershed based, as it should be. So we've kept the theme from flood plan to disaster relief regarding floods through the watershed. We will attack all of those on the preventive side with technologies that are not deployed today. We will coordinate and connect those to a single hub that is not really done that way. It's kind of by watershed, but we'll have all of those hubs reporting to the Water Development Board with all the new technology. So we're kind of working through the prevention and then the mitigation afterwards. That's a lot of federal dollars that sometimes are slow to come. I will tell you, San Angelo had 1,700 structures, 1 fatality. Most people don't even know that. They were on it during the flood and right after. They were having houses with mucked out and had their debris on the streets because they had already contracted a debris contractor pre-flood. They had it all set up that if this event happens, this is where it's going to go. They were moving debris off their streets within 3 to 5 days of that. Debris is very psychological. If you go one of these events and you just look out and you see your belongings and everything and your neighbors sitting on the street every day and it's not moving. So proper preparation on what to do when it happens is the quickest way to mitigate the impact long term. And they were stellar. So SB1 is kind of predicated. You got to know what you're going to do before you need to do it. And you're going to be trained to do it, and you're going to be drilled on to do it. And there's not going to be who's on first and who's on third conversations, because everybody's going to have their roles. And there's a succession in case you were one that got wiped out. So I think we've kind of got the right direction. It was there always, but it wasn't done and wasn't taken seriously. And clearly lack of leadership in Kerr on that issue. There was clearly no one really was in charge, and there was multiple opportunities to mitigate some of the harm that was done had somebody just been paying attention. Specifically, there was a creek that was flooding. Deputy calls in at 1:30 that morning, I think it was. Hey, Schumacher Creek's flooding. Well, the sheriff takes the call and he says, well, that's a problem, because when Schumacher Creek is, that's a predecessor to a problem, but really no action. And because there was no action, because there was nobody taking the lead, so that's gone under SB1. You don't have an option. You're going to have a leader, somebody in charge, so that when Tatum shows up or other help, you know who to go to, who's coordinating, and where everybody's at. So I think we're better for, under SB1 going forward, of prep and knowing what to do when it happens. The mitigation, unfortunately, picking up the pieces is a whole different animal.
And I deeply, deeply appreciate this clarification on local preparation, response, and recovery. This is so needed, and I look forward to voting for this bill. My question really goes to those recommendations that are for state action, for state prevention and mitigation, things like sort of the big things that were in the plan, the flood plan, were to have a statewide requirement for statewide participation in the flood insurance program under FEMA, to also require the adoption of most current maps of the floodplain identified by FEMA, to have building code requirements for structures that are allowed inside the floodplain, because we know we have more than 800,000 structures in the floodplain, and astoundingly, more than 6,000 of them are critical infrastructure, like hospitals, like schools. Indeed, I believe it was the Kerr ISD administrative building that was inundated by floodwaters and floated off its floated off its foundation. So some of these prevention and mitigation strategies that probably only the state can do. Will we build on this bill, or we'll be looking to bring different bills for prevention and mitigation?
I'm going to answer it kind of, there's a lot in that, because in order to get relief, you have to have FEMA certification. If you're not FEMA certified, you're not eligible for disaster relief when FEMA declares a disaster. So that's a whole coordinated effort. A lot of cities don't even know that they're not covered because they didn't do the plan. But in order to get that certification, you got to do a lot of what you just suggested, right? A lot of those are check the boxes to be eligible for FEMA disaster declarations and funding. Then you go into flood insurance, private and some federal. You got to have a lot of those in place. So I think there's a whole lot of stuff out there that's quasi-coordinated, but really not known. So maybe an education format. Tatum, I know this, knows those rules well. And if you're in the flood plan, if you've got a flood regional flood planning group that has put you in the flood plan for an eligible project, you're eligible under all that because you are the FEMA certified. So whatever those connects are exist today. If they need bowstring, Tatum Kid knows those as good as anybody, but Tatum understands those, and they are the deliverer of that to the communities. You need to be, and actually Water Development Board, you need to be in the flood plan if you're going to be eligible for state funding. If you're going to be in the flood plan, you need to have all of the boxes checked to FEMA. So if you're in the flood plan, you're probably there. If you're not in the flood plan, you're probably not there. If you're not in the flood plan, state doesn't have any resource for you. We did outside of Fifth today, and that's a disaster response, but you don't want to be subject to that. And there's no reason communities shouldn't, but I think most of the smaller ones don't even know they can. And so probably a little education from the Water Development Board and Tatum's help would be better served to let these, we probably can tell you who's not. We know what flood projects are in there. We know what those would qualify and what areas they impact. Probably take those regional flood groups and figure out what cities are in that flood group that are not check the boxes to get to the FEMA, because it all starts with FEMA.
It absolutely does, and you very eloquently laid out one of the recommendations in the Texas Flood Plan, right, which is state assistance to those local communities to understand what is available, what responsibilities they would have in order to be able to pull that funding right down, and also some assistance from the state. Because some of our communities, particularly our rural communities, they just don't have the bandwidth for this kind of chasing of grants.
It sounds like a good interim charge to figure out if there's an education gap there that needs to be filled. That flood plan was developed with regional, tons of meetings with locals. They did a
5 years.
Yeah, and it was really well done. And they had a big awareness at that point. But if you didn't sign up at that point, you probably had a different mayor, a different commissioner, different people in and out of those. So probably a good idea to revisit that part.
And it was a great idea of the Texas legislature to require it in 2019. So I'm grateful for that. My final question is, this bill is very good in preparation, response, and recovery. We did have some discussion about warning systems and also the public outreach to make sure that the public understands what warnings are telling them and what they need to do. That's not in this bill specifically, but I did note that the former House Bill 13 from the regular session, which is now House Bill 3, I think, 2?
2 probably.
That is hopefully coming our way.
Yeah.
And
so on the interoperability, that's something Senator Menendez and I talked about. That's coming from the House. That's kind of a House initiative. They had that conversation during session. That is a long term. That is billions plus, $1 billion plus. That is very complicated. I've been in that area, and Senator Nichols has been in that area over the years. And what's interesting to me, I hear everybody come and testify how we all ought to be connected. But when you go to the very same people that are testifying, okay, we want to connect you to him, and you're going to adopt his session, they don't want to be a part of it. So it's not quite as clear-cut and easy. And two, in this technology, it changes every year, and you don't want to be landlocked, so to speak, on a technology that had you done something different. So technology is moving that way. That's going to be a big conversation, but that's not within the scope of disaster relief today. The players, the politics, and the finances is a larger conversation. Just some of the technologies are going to SIM chips. You get 2 SIM chips in a phone. It's a $10,000 phone. Great. And when you get the SIM chips activated, then if you have Wi-Fi, it doesn't matter what device you're on. But those same technologies may be available next year cheaper in a different phone setting. So there's just a lot of moving parts on that. So interoperability of that is different. On the early warning systems, the sirens and the gauges and those kind of things, the main thing SB1 speaks to is coordination. So we have TxDOT that has gauges on low river crossings, low bridge crossings. Critical. They are the ones responsible for getting someone out there to close them off so you don't cross the bridge when there's water going over it. Those gauges are not really weather gauges. They're not that sophisticated. They're lower cost, and they have one purpose, and they only talk to TxDOT. So as we move through with new gauge systems and new coordination, those gauges have to be tied into the hub, if you will, because they are our canary in the coal mine. They are the first line of, we may have a problem when those outlying rivers start flooding. That should be the first tell that we may have to have another conversation sooner than later. So the key is here, we can have all this technology in the world dispatched and deployed, but if it's not really talking to anybody that really matters, that can make decisions from it, then it's not helping us. And right now we have a mesonet, West Texas mesonet, we have a Water Development Board mesonet, we have LCRA has some mesonet systems, and we have private sector mesonets. As we move through deploying more technologies with better coverage and some different technologies actually get a little bit closer to the footprint on the ground so that we can predict a rain bomb here possibly rather than somewhere in Texas. Those all have to be coordinated, including the TxDOT gauges, because they serve their purpose, but they could do so much more. So the main thing is on sirens and the things that we're connecting to, they got to be coordinated. I would say there's not a one silver bullet in this piece, but to your point, I didn't change National Weather Service warnings. We have flash flood watch, which is everybody gets one every day down there. Flash flood warning, which means conditions are really evolving, and then emergency. It's really too late. You've missed your window to get to safety. If your truth be known, it's like get to your bathtub and a tornado drill. It's here. So I didn't change their warnings, but I've attached action plans. So to your point, what I would envision, and I'm not speaking to what they should do, but in my mind, if you hear a siren in a flood area, that would be flash flood warning level. Seek higher ground. And if you condition people that when you hear it and only hear that only on that purpose, then as a responsible person, I can choose to go to higher ground or I choose not to. So we have to coordinate our early warning systems in a way that when we condition public, because they get very desensitized to, that they understand. And in my area, when I hear the sirens go off, Lubbock has 45 sirens. That's a sign the tornado is on the ground. Now, it may not be in my neighborhood, but we know to go to pretty much into shelter. So it's an education. You're going to have probably half the people won't care. They'll just check out. But here's what I don't have to worry about. If I have a camp or if I'm responsible for people on that riverbank that's 100 flood, I know for a fact I have to move them, and I still have time to do. So all of this is going to be a coordinated effort, because if we just spend money in pockets and don't coordinate it, we're still at mercy of federal, NOAA, and national. They do a good job, but they're very 10,000-foot view. I need those regional guys, those guys on the ground looking at the situation, those meteorologists predicting what's fixing to happen today, to be more connected. And that's what this bill does, and that's what the funding did this morning.
Thanks so much for that. I look forward to hopefully building upon this bill in the next session, looking at liability, looking at prevention and mitigation, which I think we have good recommendations for prevention and mitigation, but it requires state action predominantly. And also looking at a statewide system of warnings and interoperability so that really the state is stepping into the space of monitoring, modeling, and being the backbone of a statewide warning system in a state that has more flood deaths than any other state in the nation and will continue as our storms become more frequent and more deadly. So I think we've got a lot of work to do. I look forward to working with you on it. And this bill is a good start on preparation, response, and recovery. Thank you.
Senator Colcourse, for what purpose?
Ask questions of the author.
Do you yield, Senator Perry?
I yield.
You recognize Senator Colcourse.
Thank you, Mr. President. Thank you, Senator Perry. Thank you to the members. I especially want to say thank you to Senator Flores and Senator Campbell and yourself who suffered deaths. Senator Eckhart, I think there were 14, deaths, 10 here in Travis County on July the 5th. That sometimes are overlooked. And so I want to thank you for your leadership. When you were laying out the bill, it reminded me of the Charles Perry that I sit by on the floor, and sometimes in Senate Health and Human Services as my vice chair, you mumble through things. And while you're mumbling, everybody better be listening because you're doing something really big. I have learned that. And you were very humble in your layout. So I'm going to tease a couple of things out of you because I think that the victims and the victims' families deserve that because this is a good step forward. I echo the words of the Lieutenant Governor in the Kerrville hearing. We had a hearing here with our colleagues from the House I want to thank them as well. I thought we worked great as a panel of 16, sharing time. You and Chairman King did a very good job of allowing us to really probe, and there were lots of timelines that we looked at. Do you remember?
Multiple timelines.
And in piecing this together, Senator Flores, when we were in Kerrville, you said something really important, and I wrote it down. I like to be a note taker, especially as I get older. And Senator Flores said this about one of the counties that he represents and gives his heart and soul to. He said, this was a monster in the middle of the night. He said, a casualty and a calamity never seen before. You thanked the locals. You were very reverent. And then you said something really important that I think lends to what we're trying to craft in Senate Bill 1. Your next sentence was, the monster will be back somewhere in Texas. Truth, wouldn't you agree?
Yep, it's just a day away.
So I also want to flip to something else. I like to listen to old timers. They've been around a lot, they've seen a lot. And that's not something that we usually do now in today's world of instant, the next tweet, on to, our attention span's very, very quick. But one of the ladies that came and spoke in a panel later in the night, later in the afternoon, 25 plus hours in those two hearings, she said, I've been around here for 67 years, living in Kerr County. I've seen 25 floods. She said, our confidence has been shaken. And she said, complacency by residents had set in. It's an interesting statement by a lady who had lived in the county for 67 years. But she warned us. She said 2025 is the new benchmark versus the 1932 benchmark. Something we need to think about. And then she said, Mother Nature humbled us. Indeed. So I want to talk to something that is kind of sprinkled between these three bills of SB1, SB2, and SB3, with you kind of being the shepherd of all of this. The panel that you and your staff, and many thanks to your staff, I know it was exhausting, and they put together, they spent, countless hours putting together, making sure that we could hear what we needed to hear and probe and try to get this right. Like you said, this is the triage. Then there's the middle, where we keep working on it in the long term. Here's the question. Do you remember the panel of meteorologists?
Yep, it's the last one out. No, it wasn't. It was the one right before mental health.
Right, mental health was the last one out.
There's a bunch of weathermen.
And we listened, and we were into probably 12 hours by then, and we were listening. And I think when you look at those timelines that I referenced, and when I go through these notes, there's so many timelines. And again, one of the old timers talked about his wife having a property since 1930s along the Guadalupe on the South Fork. And he said he woke up at 2:40, and you remember that? And he said he looked out, and he said, he could see and he could feel, and he woke his wife up. It's 4th of July. They had one of their friends, and they go, we got to get out of here. And he stepped out of the back door, and he said, I stepped into water and said, never since 1930 have we seen that. And they crawled up into what he called a cedar tree, and it got all the way up to his waist, and he said, 2 more minutes of rising water, and we're done. And we knew it. And he said that was the top. And I followed him out of the room because I thought he had some really important, he was 1 mile down from Camp Mystic. And he said at that point the water was about 41 feet. And so when we look at this and how did that happen, and we look at the warnings, and oh my gosh, the warning, flood warning, all the day before, and Chief Kidd had said this, is, 2 to 3 inches, and maybe 5. And, it kind of upped. Here's the question I want to say as we look through this. all of the important things that you're doing in this. You followed up on Senate Bill 6, agreed after Harvey, where we're going to have emergency management coordinators who have more training, and we're going to do different levels. And that came out of Senate Bill 6. It was a great report, and sometimes great reports just sit on a shelf until the next disaster. So thank you for putting that in Senate Bill 1, where we're really starting to move, because these guys make they make huge calls. But on that panel, when they talked about that we don't have a weather station for 760 miles from Del Rio to Brownsville, where we could use instrumentation to get better at what we call the rain bombs. Is that right? Is that what they call?
Yep, rain bombs.
Do you think that as we do this and we pass Senate Bill 3 today, that will help us be better in predicting where these massive, intensive, do you remember the person that said it was raining a half an inch every 30 seconds, a minute, something like that? Do you think we can get better with that?
The experts tell me that there are sonar technologies that are not deployed today, that if we deploy them along with a more robust mesonet network, we can get a very close proximity to a potential rain bomb event, which Harvey was a rain bomb event at some level. This one was, Wimberley was. So these are the events that we pick up the pieces after.
And San Antonio in June.
In San Antonio in June. And obviously Sandy Creek had one of those burst. So this one came up from Mexico, that stretch of area you're talking about. One of the guys said it best, we don't want to be a recipient of it coming and being surprised. We'd like to see it coming and be able to monitor it when it gets here, when it crosses Texas boundary, so to speak. So those experts tell me this is the path. I have to trust them. They have a track record, and Texas needs real time and needs more specific locations, especially in Flash Flood Alley. If you know it's prone to this stuff, you need everything you can tell of when things are coming through that area.
I think that's hugely important. And I remember the panel that y'all put together, and it was everyone from the Texas Water Development Board and some of their experts to Rice University, University of Texas, Texas A&M, Texas Tech, and everyone was in agreement that for somewhere around 25 to 30 million, we could probably get the instrumentation. Now, you said the channel or purchase it, that the challenge is going to be how quickly can we get it. Is that correct?
Yeah, and talking to them this morning, I talked to Tech. They were at the finance hearing, and 12 months probably sonar stuff that's how long it takes to get one ordered and in place. So I would call these guys the intermediates. We can do some gauge work pretty quickly. You know, we can put some mesonets up pretty quickly, 6 months. But the actual new technology, or the technology that gives us that better insight on a regional level, is probably going to take a little longer.
Thank you for that.
Yeah.
And thank you for, I wrote down heart of the bill about predictability. We're going to do other things, instrumentation, warning signals. We're going to say seek higher ground immediately. But if we can get better at where these rain bombs are, maybe Mother Nature will humble us less. Would you agree?
Correct.
One thing I want to hit on in the bill is, or comment to, that in the Health and Safety Code, you create a new chapter in 762, campground safety. And it talks about what you and Senator Menendez exchanged about cabins for transient overnight guest use, et cetera. It goes into emergency evacuation plans for campground operators. Really appreciate that, because it was during our panel in Kerrville when we heard from their emergency management coordinator when I asked the question, do you have the evacuation plans for all the camps? And he said, there are 19 camps in this county, and I have the evacuation plans of 6. So I'll be offering an amendment to build upon 141 of the Health and Safety Code, which has to do with youth camps. And between those two, we'll combine what Senator Eckhart was talking about is a step forward And I think we have the opportunity to be in a special session, which is kind of rare. If you think back on Harvey, we didn't. Yep. And you remember the hearing that we had down in Conroe, where people woke up to a foot, 2 feet of water in their bedroom, and they didn't even know they lived in a floodplain. We have this opportunity during the special sessions to take a step forward and to get things like the instrumentation ordered right now through using, Senator Huffman, your Senate Bill 3 and the Rainy Day Fund, or the Economic Stabilization Fund, more properly said, so that we can put those dollars to work. So you can tell that I can't be more animated about how important that we get this bill passed, get 2 and 3 passed as well. The last thing I want to ask about, we went on and on in the last, in your layout actually, and I heard from many of my constituents, like almost everyone on this floor was impacted by this disaster. It was a disaster so different for many reasons. The camps, so geographically, people from all over the state of Texas, even some from out of state. You had visitors, 4th of July weekend, a beautiful part of the state. And so almost all of us were impacted. We also, almost all of us, had volunteers that went. I like to say that Texans will run to the disaster. They will run to the fire to help their fellow Texans. The volunteer part of this, and we went over this in committee a lot, was organized, but not so organized that we actually quell the volunteer spirit. So in your amendment, do you think you're going to strike that balance?
We tried. I don't think there's ever a perfect way to manage people with concerns that were raised as far as you may have a bad guy. And you know what we do down here is punish the whole for 1%. I think we found that magic mix in the sense that if you're a registered volunteer through Red Cross or any of those formal church groups that are formally recognized as a disaster relief, you're not going to need to go through that. If you're it's volunteer voyads or coads, then you're out of that mix. If you're the guy that shows up spontaneous and says, here, put me in, coach, you're going to need to go through that. And it is just a standard, it's been likened to the buying a gun website, background check. It's pretty quick. It would show any felons. And I struggle. I mean, I heard it in the committee very clearly. I also struggled with it when it was first approached to me. And it also gives a private landowner exemption. That if you're working on a private landowner to move debris for that private landowner, that was one of your issues. So we think we've accommodated all the necessary areas to address them in a way that most people that do show up, that show up and say, put me in, coach, they do go through the command center, if you will. And the conversation was the first 24 hours that may not be available. This doesn't going to stop you doing that. And there's no reason for people to come out and harass or harangue you for not having credentials that early in the game. But as it matures, command center in place, most people are going to migrate there anyway. So I don't see that it's going to be a huge issue. I've very clearly the intent, under no circumstances should someone from the state, be it TDM, DPS, or whoever, go up to somebody and say, show me your credentials effectively, and squelch the spirit. I hope it's more of a, hey, are you with such and such groups? And they know I'm an individual and say, would you mind going down and registering? I hope it's that kind of conversation. But usually that's going to be far into the process. What I didn't want to do was, the state can't be there the minute it happens. And a lot of people on ground, community-wise, are going to be out there the next second, trying to accommodate, trying to help. And those are the ones I worry about. And I don't think this bill affects those guys, because after 2 or 3 days, there's more formal structure. And that formal structure will, at that point, hope that most people would be willing to register. But the groups, and I don't know any other way to do it, because I think there's a valid concern. There are people that show up at these places with ill intent, and there are those people that show up wanting to do good. And the first time we let someone in there with ill intent that does something really bad, under the guise of volunteer, then somebody's going to point back and say, why didn't you do something? So this is that balance that we can get today. I'm welcome conversations going forward as we move through the next session probably. If there's a way to thread it needle a little quicker or a little better, I'm open to it. But I think we found, based on hearings and conversations with many folks involved and concerns that I have, it was shared, y'all shared very clearly, this is the best that we have today. So maybe it can mature into a little bit cleaner, but most people are not going to be opposed to asking if they can you register. And it's even beyond that event. It builds a database of expertise that if I'm a diver and my specialty is in that database, the state can go there. It also builds a potential workforce development down the road. But
Correct.
So it does multiple
and
things.
I just want to highlight one more thing, because Senator Hughes, I remember during Harvey when you showed up with Representative Cole in a boat. I think Senator Bettencourt, you were there. And there were hundreds of people down in Harris County in boats rescuing people off their rooftops, out of their homes. So perfection is the enemy of the good sometimes. And so I look forward to working with you on this. I think there were a lot of exchanges during the hearing about this. And I know whether it's Texas Department of Emergency Management or DPS and how we organize this moving forward, but not to squelch, your word, quell the Texan spirit to like what inspired Brian Hughes, Senator Hughes, and Representative Cole to get their bass boat and come down and rescue people because we needed you to. And so I look forward to working with you. Thank you for your work on this. When we started it, it was so big that you almost say, how do we craft this? Where do we start? But you had to start doing it. You had to put pen to paper, and you did. It's a good step forward. And I think it gives us a really, like Senate Bills 6, 7, and 8 that you were a part of after Harvey, another way. You've seen one disaster, And we learn something after every one, but our goal is to save lives. So thank you.
Senator Alvarado, for what purpose?
To ask the author a few questions.
Do you yield, Senator Perry?
I yield.
You recognize Senator Alvarado.
Senator Perry, did Senator Kokor say that Brian Hughes, Cole, and Bettencourt were all in one boat together?
It was a big boat.
Okay. Well, that's why I was asking. I had a visual, and things weren't adding up.
They docked at the Bettencourt Marina.
Okay. Senator Perry, I want to thank you for your work and all of the members who served on the select committee. Your bill covers a lot of areas tending to things that local government entities need, the community there, but also you recognize the importance it is to get some of our small businesses up and running, correct?
Right, and it was your bill that was incorporated into that was out last session. So.
Yes, and I'm glad that it was incorporated in there. It passed out of here and died on the House calendar, and then we refiled it again. And I just wanted to also thank the groups that supported our bill, which was the Texas Restaurant Association, the National Federation of Independent Businesses, and many others. So thank you for your work on that, and I'm happy to support the bill.
Thank you.
Members, are there any other questions of Senator Perry? All right. Senator Perry moves suspension of the regular order of business on committee substitute Senate Bill 1. Is there objection? Hearing and seeing none, rules suspended. Chair lays out on second reading committee substitute Senate Bill 1. Secretary will read the caption.
Committee substitute Senate Bill 1 relating to disaster preparedness, response, and recovery.
Members, there is an amendment. Secretary will read the amendment.
Floor amendment number 1 by Perry.
Senator Perry on the amendment.
Mr. Members, this is an amendment I spoke to earlier through multiple conversations. It does 6 things. It cleans up the JPs area, which was fairly complicated and broad because of some statutes that were currently in transition. Specifically, this amendment clarifies that they only are working on the autopsies and not full inquests. So that was a distinction that the JPs thought was important. Secondly, the amendment requires cities and counties to adopt procedures implementing the line of successions the bill creates for emergency management coordinators, our directors. That was not as clear as we liked, so that basically sets it out there that it's required. Third, it creates an exception to the annual drill requirement for emergency management plans, such as local emergency managers do not need to drill their plans if they have had a disaster in the most recent 12 months. Fourth, the amendment narrowly focuses the volunteer management system on spontaneous volunteer, incorporates the exceptions to the volunteer registration requirement for volunteers that are part of a VOAD or a COAD. Fifth, the amendment cleans up some minor drafting issues. Lastly, in the meteorologist panel, we had this individual present representing UT Arlington as a counterpart or a complement to Rice, but they were not specifically listed in the bill, and they will be on the panel to establish the new meteorological framework with additional gauges and mesonet systems. So this just puts them formally on the panel. They should have been there in the original format. With that, I move adoption.
Members, the motion is on the adoption of floor amendment number 1. Is there objection? Hearing and seeing none, the amendment is adopted. Members, there is an amendment. Secretary will read the amendment.
Floor amendment number 2 by Blanco.
Senator Blanco, you're recognized on floor amendment number 2.
Thank you, Mr. President. Members, during the invited testimony, Texas Division of Emergency Management, Chief Nim Kidd testified that under existing statute, the county judge, the county sheriff, or person responsible for emergency management shall be required to undergo emergency management training. There is no explicit requirement that all 3 positions receive this training. So this amendment will require all county judges, county sheriffs, and mayors of a municipality that is not covered by a county's hazard mitigation plan to complete a training course provided by TDEM every 2 years. This amendment is going to ensure that the continuity of trained leadership during an emergency and help strengthen local responses to emergency situations and improve community readiness. With that, I believe it's acceptable to the author.
It is acceptable to the author.
Senator Perry on the amendment.
It is acceptable to the author.
Members, motion is on the adoption of floor amendment number 2. It is acceptable to the author. Is there objection? Hearing and seeing none, the amendment is adopted. Members, there is an amendment. Secretary will read the amendment.
Floor amendment number 3 by Flores.
Senator Flores on the amendment.
Mr. President, members, this amendment strengthens our disaster preparedness by requiring certain campgrounds in Texas to meet the National Fire Protection Association's NFPA 1194 standards. These standards are nationally recognized best practices for recreational vehicle parks and campgrounds. They address fire protection, electrical safety, and other critical safeguards that can make the difference in an emergency. Importantly, they also align with the spirit of Senate Bill 1 to ensure our community's visitors and first responders are better prepared when disaster strikes. Many people staying at campgrounds or recreational vehicle sites are from out of town, sometimes from out of state, and are less familiar with local hazards or evacuation routes. The NFPA 1194 standards help bridge that gap by requiring clear emergency signage, safe access routes for evacuation, and proper spacing and infrastructure to reduce hazards during floods or fires. These measures ensure that operators have a concrete plan and visitors have the information they need to respond quickly and safely in the event of a disaster. I move adoption. I believe it's acceptable to the author.
It is
Senator
acceptable.
Perry on the amendment.
It's acceptable.
Members, the motion is on the adoption of floor amendment number 3. It's acceptable to the author. Is there objection? Hearing and seeing none, the amendment is adopted. Members, there is an amendment. Secretary will read the amendment.
Floor amendment number 4 by Colcorst.
Senator Colcorst on the amendment.
Thank you, Mr. President. Members, this is a follow-up from the hearings and some of the feedback that we received, and a partial insertion of Senate Bill 60, which goes to Chapter 141 of the Health and Safety Code that covers youth camps. It'll require youth camp operators to include emergency plans in their emergency plans, muster zones. Those are meeting spots, create procedures to identify all campers potentially impacted by an emergency, and establish standard procedures to notify and communicate with local emergency management services, camp administrative and medical service staff, and parents or legal guardians of each camper. Appreciate Senator Perry working with me on this amendment.
Senator Perry on the amendment.
It's acceptable.
Members, the motion is on the adoption of floor amendment number 4. It's acceptable to the author. Is there objection? Hearing and seeing none, the amendment is adopted. Senator Perry, you're recognized for a motion.
Move passage to engrossment.
Members, Senator Perry moves passage to engrossment. Is there objection? Hearing and seeing none, bill is passed to engrossment. Senator Perry, you're recognized for a motion to suspend the constitutional 3-day rule.
Move to suspend the constitutional 3-day rule.
Members, Senator Perry moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Bettencourt, Blanco.
Being 28 ayes and no nays, the rule is suspended. Chair lays out on third reading and final passage. Committee substitute Senate Bill 1. Secretary will read the caption.
Committee substitute Senate Bill 1 relating to disaster preparedness, response, and recovery.
Senator Perry, you recognized for a motion.
Yeah, I want to say thank you to my House counterpart, Chairman King, and those members, as well as the members on the Select Committee, and my staff, Andrew Parks and Jenna Grove, and all the energies and efforts. I will tell you, after doing a couple of these, Senate Bill 8, Flood Bill, or 7 back in the day, 8, the hearings were absolutely the best resource for this bill. They were clear. People knew exactly what went wrong, and they could tell us in very articulate terms, and the members did a good job of putting it together. So with that, I move final passage, committee substitute Senate Bill 1.
Member Senator Perry moves final passage. Committee substitute Senate Bill 1. Secretary will call the roll.
Alvarado, Bettencourt, Blanco.
There being 28 ayes and no nays, the bill is finally passed. Congratulations, Senator Perry. Senator King, you're recognized for a motion to suspend the constitutional 3-day rule on committee substitute Senate Bill 14.
So move.
Member Senator King moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell,
There
Blanco.
being 23 ayes and 5 nays, the rule is suspended. Chair lays out on third reading and final passage. Committee substitute Senate Bill 14. Secretary will read the caption.
Committee substitute Senate Bill 14 relating to certain files maintained by a law enforcement agency regarding certain employees of the agency.
Senator King, you recognize for a motion.
Move final passage.
Member Senator King moves final passage. Committee substitute Senate Bill 14. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco.
Being 18 ayes and 10 nays, the bill's finally passed. Congratulations, Senator King.
Thank you, members, and thank you for suspending.
Senator Bettencourt, you're recognized for a motion to suspend the regular order of business. That could be considered committee substitute Senate Bill 2.
Thank you, Mr. President and members. SB 2 is a great follow along to the SB 1 bill that was laid out so well by Chairman Perry. With the recent devastation and how critical early flood warning systems could be to public safety, Senate Bill 2 basically outlines how to do that in a procedural format that makes requires the Texas Water Development Board to identify areas that have a history of severe flooding, as well as other relevant factors such as loss of human life to flooding and existence of residences or other dwellings in flood-prone areas. Upon identifying these key areas, the board will direct the municipality or county on where to install an outdoor warning system. I think everyone here recognizes that we, after watching these rural river systems, and I believe idyllic is a term that we all will think of when we think of the Guadalupe River, are obviously subject to massive flash floods. In this particular case, a wall of water that raised the river 26 feet in 45 minutes. Whether we have youth camps, RV parks, or other large gathering sites near these flood-prone rivers with a siren system integrated into a early warning system that uses current technology, which by anyone's estimate, flood warnings are part of what the public needs to hear. So we're really adding an auditory component in these river flood watersheds to go along with the system alerts that people are getting on their cell phones. And there's two statistics I want to bring out. Then I want to talk about the testimony in Kerrville. One is that Texans have learned to turn off their alerts 29.5% of the time. That's 6 times more than Vermonters do. Also, we have about 18% of those folks using cell phones turn them off at night. So no matter what the equation is, you end up with almost half of the people that are not going to be able to hear a warning just on their cell phone, but they might be able to hear an old school technology siren. And Senator Perry made a great comment about the Kerrville testimony, because there was, unfortunately, in my mind, an anti-river warning system bias in that county based on as far as back as an engineering report about 10 years ago. And when the president of the Upper Guadalupe River Authority testified that he wasn't sure such a system would help, he had just laid out the fundamental facts, which is that wall of water was headed downstream at 17 miles an hour and had a 7-mile uptake on what it would take to get to that first major campsite. And simple Aggie math, Senator Flores tells me that that's 24 minutes of warning time. The obvious conclusion is the only way you survive a 26-foot wall of water coming at you is to get out of the way. And with that testimony, I actually asked the president if he would reconsider his remarks, Chairman. And you remember he said yes. And Senator Flores, you remember I asked the county officials, starting with the emergency management coordinator, the sheriff, and the county judge. And they all recanted that public discussion that there was not any advantage to a flood warning system. And I'm glad to see that, because we have to recognize the obvious. So that's what this bill does. In addition, the Water Development Board shall require the appropriate municipality or county to install, maintain, or operate one or more outdoor warning sirens following the rules adopted by the board. If the installation is within the boundaries of municipality, the municipality shall install, maintain, and operate the siren. I thought the testimony of the mayor of Kerrville was especially promising, because he clearly understood the need for this. And in unincorporated areas of the county shall install, maintain, and operate the siren. We first started talking about Senate Bill 2 after both the governor and lieutenant governor said that this would be an item be paid for by the state with Lower Colorado River Authority. I want to thank them for their input into the bill, because they're clearly a best-in-class operation that we can use from gauging and then up into a river warning system using sirens. I want to thank Chairman Huffman, who is following along, I'm sure, here with the money that was laid out in SB 3 today. And lastly, the bill allows for the use of any money being made available from the state to assist municipalities, counties, and other governmental entities in covering the cost and installation of outdoor warning sirens. The grant program will be administered by the Office of the Governor, be funded in SB 3, as I mentioned, but importantly, the governor said that we need to try to get these systems in within less than a year, and the governor's office is the right place for the money, given the fact that we have to show some alacrity in getting this done. And with that, I move suspension of regular order of business to take up the committee substitute to Senate Bill 2.
Senator Eckhart, for what purpose?
Ask questions of the author.
Do you yield, Senator Bettencourt?
Certainly.
You recognize Senator Eckhart.
Thank you so much, Senator Bettencourt, and I appreciate your focus on sirens. My question is, why just sirens?
Well, I think it was a need to reinforce what can't happen if the public turns this off at night, or doesn't have it, or the campers are too young, because the obvious focus is you've got to get people to higher ground. And so I can see sirens, not just itself, but also an auditory warning that says, you know, this is a flash flood emergency, move to higher ground. So I think with this modern technology, we can do both an auditory and a verbal message. But the telling part, Senator Eckhart, and I know you were at the hearing because you were in the back of the audience. When the River Authority president said he wasn't really sure it would really help. And then he said, but, you know, that wall of water is moving at 17 miles an hour, and we had to go through 7 miles to get to the populated area. They hadn't done the math in their head. 24 minutes. Wow, if Senate Bill 1 had passed and there were sirens out there, if they had a plan, we could have saved a lot of lives by moving vulnerable people to higher ground. So the sirens, I think, are just a throwback to all of our age, okay? Where, did you do duck and cover drills? I know that the president...
I think I'm a little too young for the duck and cover, okay, but I'm aware of them. And so, yeah, it's a yes and. Yes,
right.
Yes, sirens and. Yes?
Right.
Was there any discussion of landlines, the issue with landlines? We used to use landlines to notify, but most people have gotten rid of them.
We did look at some studies because there's IPAWS and some other federal studies. Unfortunately, landlines don't get through now 51% of the time. So that technology is fading. And really, when you look at the one commonality of all the river authorities that have dams is that if there's a release, they've got a downstream siren that's blaring away saying there's a release. And I think people know that, that live in these river watersheds. So I think it's a recognition of the obvious. Look, I mean, I filed the bill. I had the idea, but the idea was all over Fox News and 100 other outlets. You know, CNN, pick a name, because it's just again, you've got to do everything we can to get people out of harm's way.
We do. And next question. So along with why sirens, why just the counties in the disaster declared in July of this year?
Well, actually, if you notice the bill pattern, it's those counties plus whatever's available on the funding side. So we do leave an opening for other counties. For brevity of getting these bills to the floor, we use that as an amendment on the committee substitute.
Oh, so let me understand your response. So as it's currently written, this bill requires sirens,
right,
but only in the counties where there was a flood disaster declaration from July 2025. But Senate Bill 3 opens up a pot of money for sirens in any county.
Right. We use some language that we passed through Senator Perry to basically we'll have that opening of that, because in a perfect world, we would have geocoded Flash Flood Alley, but that was a rather difficult thing to do given the amount of time that we had to file the bills. But that's there now. And so we'll see. Obviously, the important thing is to get these counties that were hit hardest help first, and then we'll see how far the money goes from there.
But you and I, we both recognize that actually all 15 regions in the Texas flood plan have flooding issues. It's not just the hill country, right?
No, if you look at the watersheds that we were talking about, they really started from, from the Colorado River down, during this cycle. But yes, there's possibilities of it. Now, some areas, we have such good gauge systems in Harris County because of the emergency management. Those actually gauges go through comms and their communications through the appraisal district. So you might have a flood in a bayou area, but that's not, that's going to add X number of inches or feet. But it's a little bit more slow moving of an event compared to these flash flood walls of water that, come down 26 feet in 45 minutes, or the record, I think, was the Brio at 45 feet.
So nearly, I believe the number from the flood plan is that 21% of the land in Texas is in the 1% floodplain. So this bill, isn't that astounding? That's in the flood plan.
Good, wow.
21% is in the 1% floodplain.
Well, we're well irrigated and therefore vulnerable. Okay.
More than 800,000 buildings are in the floodplain. So this bill addresses just sirens and just in the counties where the last flood
That's
occurred.
where it starts. It's sirens, communication towers. Some of the discussions we've had are because you're in these difficult to reach areas, you can't rely even on 5G. So we'll need some type of Starlink equivalent communication ability. In a perfect world, they'll take the gauge information that exists and be able to belt out a siren, or end up with a verbal alarm. But that's what we're aiming for.
So this is a great start, and I applaud you for reaching back to an old technology that is it's absolutely a yes and in the arsenal in a state that is experiencing more flood deaths than any other in the nation. Thanks.
Thank you.
Senator Menendez, for what purpose?
Thank you, Mr. President. Questions of the author?
Do you yield, Senator Bettencourt?
Certainly.
You recognize Senator Menendez.
Thank you, Mr. President. So, Senator Bettencourt, thank you for just taking a little common sense approach to this problem. And I think the 13 plus hours that we sat through in Kerrville helped sort of illustrate, and especially, I don't know if you remember the gentleman who had been dealing with stage 4 cancer, the former firefighter. Remember, he said he opened his door and he saw the flood waters rushing by and the people in there.
And one RV after the next crashing in the screams. Yes, I unfortunately will remember that the rest of my life.
Yeah. And so I do believe that these sirens can work. I guess the question that I have is, once they're installed, because a lot of the debate, I think, has come up over maintenance and operation, who would be responsible ultimately once, I guess, the Water Development Board provides a grant?
Well, once they're installed, the maintenance activity right now is the municipality or the county. Okay. Now, we've talked about some basically trying to use a fund and basically endow the M&O expense on this, and I think that would be a good next step. But at this point in time, I think the obvious conclusion is get them in, then we can find out what we're dealing with economically, and then we can write that as the next bill. But I would support that because, we're telling him what to do and how to do it. And to Chairman Perry's point, this isn't the answer. Sirens are like a auditory component that everybody sees. The whole framework plan is important.
Right.
But I do agree that depending upon the technology that's selected, the maintenance costs would be something the state should look to pay for in the future. But we just didn't include it in this pattern yet. Because quite frankly, we don't know what the number's going to be.
Yeah, absolutely. And as this bill moves forward, I mean, I remember one of the, naysayers mentioned that you probably wouldn't be able to hear the siren inside. And I think I sat there and I thought to myself, what if there was technology that could trip a smoke detector to go off if water is going on? And because we all know that smoke detectors are someone's going to awaken people in the house.
There was actually very poignant testimony from some Houstonians that were awakened by water sensors on the floor that popped.
That's right.
And that's a simple float switch that saved their lives. And without trying to make too fine a point on it, but the importance is, I don't care what method we use, we just have to get people's attention.
Yeah.
Now, we also discussed, if in a different setting, if you're in a river crossing setting, sirens blaring away is not the right answer.
Right.
You might have stanchions that come down and lights that flash, because one thing you don't want to do is have a siren for every possible, system, and every possible problem, because you're going to have false positives and false negatives.
Right.
And so you really want to make this, if this is a siren, and I think the combination of siren and an auditory that says this is a flash flood emergency, move to higher ground, because that's really the testimony we took.
Yeah. And I completely support this. I just wonder, because we had heard also testimony that the River Authority of the Upper Guadalupe River Authority had applied for something similar and had the money in hand, and so, but they decided not to. And so I'm wondering if at what point do we choose to look at the river authorities in these flash flood alleys and ask them, where is their responsibility?
Well, I think Chairman Flores and Chairman Perry know that in SB1 there's a line item about the Upper Guadalupe River Authority doing a limited sunset, or at least there was last time I read the bill. I think that's important. After that discussion, look, I was, in my mind, relentless getting the answer to, are these river alert or flood warning systems going to save lives? Because I was kind of astonished and appalled at what I saw in these engineering reports, that somehow these wouldn't make any difference. They clearly would make a difference.
Sure.
So that's why I asked all 4 elected officials, and they have decided, at least publicly, they said the cash flow that they had built up, which I'm going from memory, is $3.4 million.
Yes, correct.
They've said they want to put $1.5 million into a river warning system, at least from the Upper Guadalupe River Authority portion. So again, that's a recognition of the obvious. That should have been done 2 years ago.
Yeah.
And the grant that they got was a 5% award plus a 30-year no interest-free loan, and doing the math in my head now, it's about $31,600 per year cost, which is nothing. And one last thing, there was discussion about they were at the no new revenue rate. They actually had reduced their tax rate below the low new, and it just, Bad decision, no question about it.
You and I had a similar conversation that day while they were testifying, and we were appalled at, in my words, in my opinion, the level of irresponsibility towards their residents just because they were trying to be fiscally conservative, I guess. I don't know what it is, but it's a disdain for the obvious. The obvious is we need these flood warning systems, especially in these flash flood prone areas. Look, I've spent a lot of time as a kid and young adult in the Guadalupe River. It's an idyllic place, 5,000 days in a row, but then there's one day that it's not. Yeah, well, thank you for your bill. Appreciate it. I look forward to voting for it, and we'll look forward to continuing to work on how we can improve the warning to people when the disaster strikes. So
because you've had one in San Antonio that came out of the blue.
Yeah, we lost 13 people in the June prior to the July flooding, and that's a whole nother story. People on the highway late at night as well. So we need to address that as well. Thank you very much.
Thank you, Senator.
Thank you, Mr. President.
Member Senator Bettencourt moves suspension of the regular order of business on committee substitute Senate Bill 2. Is there objection? Hearing and seeing none, rules suspended. Chair lays out on second reading committee substitute Senate Bill 2. Secretary will read the caption.
Committee substitute Senate Bill 2 relating to outdoor warning sirens in flood-prone areas.
Senator Bettencourt, you recognized for a motion.
Thank you, Mr. President. Move passage and engrossment of the committee substitute to Senate Bill 2.
Member Senator Bettencourt moves passage to engrossment. Is there objection? Hearing and seeing none, bill is passed to engrossment. Senator Bettencourt, you recognized for a motion to suspend the constitutional 3-day rule.
So moved, Mr. President.
Member Senator Bettencourt moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Bettencourt.
There being 28 ayes and no nays, the rule suspended. Chair lays out on third reading and final passage. Committee substitute Senate Bill 2. Secretary will read the caption.
Committee substitute Senate Bill 2 relating to outdoor warning sirens in flood-prone areas.
Senator Bettencourt, you recognized for a motion.
Thank you, Mr. President. Move final passage of the committee substitute Senate Bill 2.
Member Senator Bettencourt moves final passage. Committee substitute Senate Bill 2. Secretary will call the roll.
Alvarado, Bettencourt,
There being 28 ayes and no nays, the bill is finally passed. Congratulations, Senator Bettencourt.
Thank you, Mr. President and members.
Senator Huffman, you recognize for a motion to suspend the regular order of business, take up and consider Senate Bill 3.
Thank you, Mr. President and members. At this time, I move to suspend the regular order of business and any other necessary rules, take up and consider Senate Bill 3. Members, this bill is the bill that we laid out in finance this morning, and it is designed to be the funding bill that's going to address the urgent critical needs of the recent flood victims. It works in tandem with Senator Perry's Senate Bill 1, Senator Bettencourt's Senate Bill 2, and it establishes the framework to fund the initiatives set forth in their legislation. It ensures that the resources are readily available to support ongoing disaster response and recovery, because that's still going on today as we speak, and to strengthen our preparedness for future flooding disasters in the areas that were directly impacted by the recent tragedy. It reflects our commitment to standing with those who have lost so much and ensuring that Texas emerges stronger and more resilient. Specifically, what Senate Bill 3 does is it appropriates $200 million to cover the projected 25% non-federal matching funds for FEMA reimbursement, $50 million for the purchase of sirens, rain gauges, and other equipment in the Central Texas flood region, which aligns with Senate Bill 1 and Senate Bill 2. And just to clarify, because I think there was some questioning of Senator Bettencourt, I think with Senator Eckhart, and I don't want the record to be muddy on this, the funding for this is just for the counties that were part of the disaster declaration, and they must participate, and the funding is for them and any other counties that may be named later, but part of this same event. And then $24 million to develop enhanced atmospheric measurement and modeling techniques to improve weather forecasting accuracy and improve flood management and the timeliness of flood warnings. And finally, $20 million toward a new swift water training facility. It's called Storm Ranch, where first responders can receive training in swift water rescue in Texas rather than traveling to other states. Members, this bill appropriates funding out of the Economic Stabilization Fund. We have a historic balance in the fund, and the items in this bill are one-time and, of course, specifically aimed to address this catastrophic rainy day disaster. So I can't think of a better use of this fund than for this tragedy. In conclusion, Senate Bill 3 represents not only a response to the challenges of today, but an investment in the safety and prosperity of these communities moving forward. And I will have a couple of cleanup amendments that are minor. One adds a county that we inadvertently left out, and that's Guadalupe County. And then also the effective date of the bill will be September 1, and that's just to flow with some funding issues. And that's what I have, so I move to suspend the regular order of business.
Senator Eckhart, for what purpose?
To ask questions of the author.
Do you yield, Senator Huffman?
Of course.
You recognize Senator Eckhart.
Thank you so much, and thank you, Senator Huffman. And you did clarify, so I just wanted to make sure I understood. There are 4 different pots of money in this bill.
Correct.
Very, very appreciated. The first one, the $200 million, I think I heard you say that the $200 million is reserved for the match to pull down the FEMA dollars.
Correct, yes.
So that will cover the locals match or the state's match?
I believe that it covers both. Yes. Yes, in categories A and B, correct, yes.
Thank you so much.
Yes.
And that $200 million, is that just for the counties affected in the July 2025 floods?
Yes, the ones that were part of the disaster declaration.
So 3 of the 4 pots, the $200 million, the $50 million, and the $24 million, are all confined only to the counties that were affected in the 2025 floods, or in one section it says hill country counties.
Right, let me double check on the third pot, the $24 million for the developing the advanced atmospheric measurement. Mm-hmm. Because they're going to double check, because I'm not positive on that, how that was set up.
I would appreciate that.
Yes, but the other two, the $200 million and the $50 million for the purchase of the other items or the federal match are for the declared disaster zone. The other one, since it's kind of more of a research issue, I'm not certain. So we'll check on that, and I'll get that back to you before we conclude today.
And that goes to my point with regard to Section 3. It seems, and I'm wondering if you would consider opening up Section 3, not just only, and I'm a Hill Country senator, so this is might be viewed as against my interests. However, to remove its cordoning to Hill Country only, since this is its purpose is atmospheric measuring, modeling, and improving meteorological forecasting and enhancing weather intelligence and forecasting accuracy, improving flood management and timeliness of flood warnings. I would suggest we would need that statewide, and even a forecasting that looks like a rain bomb is hitting San Angelo, for instance, may end up hitting Lampasas.
And I do see in the language, it says the Texas Hill Country, which is a little different wording than the rest of the bill. I'm going to ask Senator Perry if he can add something. I'm happy to yield to him because I want to make sure we get it perfect. And he's the expert on this subject, and he was in all the hearings. So I yield to Senator Perry.
Senator Perry, for what purpose?
To add some commentary to the question that was asked by Senator Eckhart.
You're recognized.
Yes. So that is a statewide application. So there's West Texas Mesonet that covers a large part of the west, kind of Abilene West. There's Texas Water Development Board that has their coverage area. And then there's private and there's LCRAs. There's multiple Mesonet systems. This one is meant to cover blanket coverage where there is no coverage. We mentioned 700 miles. It will focus on some gauge issues. So it's meant to be a statewide hub in its inception. The plan is to where Water Development Board, we believe, is the best source to gather that. But it's going to be additional gauges, specifically flash flood, and Mesonet tires in Flash Flood Alley. But remember, Flash Flood Alley goes up to Dallas. I mean, it's a pretty broad swoop, but it's meant to bring the state income up to all of the areas. The upper East Texas area doesn't have much coverage at all, and I've asked, and that's kind of the area they don't see a need for it at some level, but this is intended to bring the state in a complete network across the board, coordinating with other existing providers and connecting those dots. So it's meant to be beyond this issue and those 13 or those 20-something counties. It's meant to be more broad in application, and it's really expanding what's already in existence. So does that help?
I completely agree with you. My concern is that because it says in the Texas
the way
Hill
it's
Country,
worded, sure.
that perhaps that's in error because, of course, these kinds of enhanced atmospheric measurements go beyond just rain bombs.
Right. This is going to be talking about fire episodes in the Panhandle with
Absolutely.
this Mesonet connection.
Red flag days.
It's a whole lot of disaster preparedness and prediction and forecasting that's not just flood related, but it's an expansion of existing to cover the non-covered and focused intense applications on additional gauges that tie in as well as Mesonets. They'd already, Water Development Board was already working on a plan prior to flood. And this is just to kind of complement and add to what's in existence from all the different providers.
So really my question goes to perhaps the intent here is not adequately reflected by the language, and perhaps we should take a short pause just to marry the language to the intention for Section 3.
Go back, Senator Perry.
I yield back.
Yeah, I don't think that's necessary, Senator Eckhart. This will be a grant program through the governor's office. This is a project I think that's been Texas Tech is working on. I think we're all on the same page working on making sure that this new technology is developed and this money is intended to help develop it. And so I'm confident that the governor's office will work in a way with Texas Tech and the interested parties and the Water Development Board to ensure that they get the maximum use out of the funding. And I'm certain that that's something that when we come back next session that they will all be reporting on to us on to their progress. And I wouldn't be surprised if they ask for more money. So we'll follow that carefully, but I don't think we need to slow the bill down for that.
Thank you for that. I was concerned that our language in legislation limits the trusteed funds of the governor. And perhaps I'm mistaken.
I think that we're all on the same page on this.
And then finally, the final pot of money, the $20 million, goes to a specific emergency service district in Harris-Fort Bend for swiftwater rescue, which is definitely needed. Is this intention that this swiftwater training facility is available to firefighters and first responders from anywhere in the state?
anywhere in the state. It's a statewide, it'll be a statewide use, and the Texas Military Department will be able to use it as well as out-of-state first responders would be eligible as well to use this. There's only 2 or 3 in the nation. This will be one of the few available. We had firefighters who testified this morning that this will be a great benefit to firefighters throughout the state, first responders, including anyone who engages in rescue. So it could be, game wardens, police officers, whoever needs the training. And they also noted that, for example, during this most recent tragedy, that they did have out-of-state responders who came to work with Texans. And so training with them will actually be highly beneficial, because the ones who would come and train would most likely be the ones who would respond as well to a huge disaster. So many times they would be training with first responders from Texas. So there's great advantages to doing this. And again, it'll be up and running. They've been working on this for a while. They have about, I think they said 51, 57, I don't remember, million in local funds already towards the development of the project. So the state's money will help them finish it up and be finished in 12 to 15 months, ready for training.
It's a wonderful thing to share that kind of training resource with emergency service districts and first responders all across the state of Texas. Of course, we also have experienced that on numerous occasions where not just training, but also swift water boat rescue equipment is not often available to every ESD. Some ESDs just don't have that capacity.
Yeah.
So perhaps we could work in the future. I believe it was Senator Sparks who did an inventory of all fire apparatus across the state, and we might want to amend it to include all flood and swiftwater rescue apparatus for sharing across the state as well. Thank you very much for answering my questions.
Thank you.
Members, the motion is on suspension of the regular order of business. Is there objection? Hearing and seeing none, rules suspended. Chair lays out on second reading, Senate Bill 3. Secretary will read the caption.
Senate Bill 3, relating to making supplemental appropriations for disaster relief and giving direction and adjustment authority regarding those appropriations.
Members, there is an amendment. Secretary will read the amendment.
Floor Amendment number 1 by Huffman.
Senator Huffman on the amendment.
Yes, members, this just changes the effective date from immediately to September 1, which is the new fiscal year, and obviously in practical effect, it's going to make very little difference. It's just a fiscal issue, so I move adoption.
Members, the motion on adoption of floor amendment number 1. Is there objection? Hearing and seeing none, the amendment is adopted. Members, there is an amendment. Secretary will read the amendment.
Floor Amendment number 2 by Huffman.
Senator Huffman on the amendment.
Yes, I believe this is the one that adds Guadalupe County to the list of eligible counties. It was inadvertently left off the initial. Let me make sure it's what it says. Yes, Guadalupe, that's it. It was initially left off. Move adoption.
Members, Senator Huffman moves adoption of floor amendment number 2. Is there objection? Hearing and seeing none, the amendment is adopted. Senator Huffman, you're recognized for a motion.
I move passage to engrossment of Senate Bill 3.
Member, Senator Huffman moves passage to engrossment. Is there objection? Hearing and seeing none, bill is passed to engrossment. Senator Huffman, you're recognized for a motion. Suspend the constitutional 3-day rule.
So moved, Mr. President.
Member, Senator Huffman moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Bettencourt,
There being 28 ayes and no nays, the rule is suspended. Chair lays out on third reading and final passage. Senate Bill 3. Secretary will read the caption.
Senate Bill 3, relating to making supplemental appropriations for disaster relief.
Senator Huffman, you're recognized for a motion.
Move final passage of Senate Bill 3.
Member, Senator Huffman moves final passage. Senate Bill 3. Secretary will call the roll.
Alvarado, Bettencourt,
There being 28 ayes and no nays, the bill is finally passed. Congratulations, Senator Huffman.
Thank you, members.
Dean Zaffirini, you're recognized for a motion to suspend the regular order of business, take up and consider Senate Bill 43.
Thank you, Mr. President. Mr. President and members, I move to suspend the Senate's regular order of business in order to take up and consider at this time Senate Bill 43, relating to an exemption from the requirement to obtain a permit from TCEQ for certain dams or reservoirs operated and maintained for the purposes of erosion, floodwater, and sediment control. This bill, members, was passed unanimously by the Senate last session, but it died in the House on the calendar. Plum Creek Conservation District manages 28 flood control structures on the tributaries of Plum Creek in Hayes and Caldwell counties. Senate Bill 43 would impact them and the 2,039 dams across Texas. Flood control dams catch and store floodwaters during normal and extreme rain events and then release them downstream at an engineered rate. Some of the dams are more than 60 years old and need maintenance, rehabilitation, and repair. Usual permitting to maintain dam structures is a long and slow process, taking up to a year. Generally then, Senate Bill 43 would define a qualified local sponsor, allow a qualified local sponsor to use a permit exemption to, first, construct or maintain on property owned or controlled by the sponsor a storage facility of not more than 200 acre-feet of water for the purposes of erosion, floodwater, and sediment control, and second, divert water from the reservoir as needed for the limited purpose of using it to repair, maintain, or rehabilitate the dam or reservoir, and specify that the exempt status would not change as long as the district owns the reservoir. Mr. President, I move suspension.
Members, Dean Zaffirini moves suspension of the regular order of business on Senate Bill 43. Is there objection? Hearing and seeing none, rules are suspended. Chair lays out on second reading Senate Bill 43. Secretary will read the caption.
Senate Bill 43, relating to an exemption from the requirement to obtain a permit from the Texas Commission on Environmental Quality for certain dams or reservoirs operated and maintained for the purposes of erosion, floodwater, and sediment control.
Dean Zaffirini, you recognized for a motion.
Thank you, Mr. President. I move passage to engrossment.
Members, Dean Zaffirini moves passage to engrossment. Is there objection? Hearing and seeing none, bill is passed to engrossment. Dean Zaffirini, you recognized for a motion to suspend the constitutional 3-day rule.
Thank you, Mr. President. I move to suspend the constitutional rule that bills be heard on 3 several days.
Members, Dean Zaffirini moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Bettencourt,
There being 28 ayes and no nays, the rule is suspended. Chair lays out on third reading and final passage Senate Bill 43. Secretary will read the caption.
Senate Bill 43, relating to an exemption from the requirement to obtain a permit from the Texas Commission on Environmental Quality for certain dams or reservoirs.
Dean Zaffirini, you recognized for a motion.
Thank you, Mr. President. I move final passage.
Members, Dean Zaffirini moves final passage SB 43. Secretary will call the roll.
Alvarado, Bettencourt,
There being 28 ayes and no nays, the bill is finally passed. Congratulations, Dean Zaffirini.
Thank you, Mr. President and members.
Senator Perry, you're recognized for a motion to suspend the regular order of business on committee substitute for Senate Bill 13.
Thank you, Mr. President. Members, the impact fee credit bill passed unanimously off the Senate. Didn't get through the House last session, and it basically gives local governments the ability to credit builders and development for innovative water supply strategies. So we go from floods to more water supply conversation. With that, I move to suspend the regular order of business committee substitute Senate Bill 13.
Senator Perry moves suspension of the regular order of business on committee substitute for Senate Bill 13. Is there objection? Hearing none. Rules are suspended. Chair lays out on second reading committee substitute for Senate Bill 13. The Secretary will read the caption.
Committee substitute Senate Bill 13, relating to the provision by a political subdivision of credits against impact fees to builders and developers for certain water conservation and reuse projects.
Senator Perry, you're recognized for a motion.
Move passage to engrossment.
Senator Perry moves passage to engrossment. Is there objection? Hearing none, bill is passed to engrossment. Senator Perry, you recognized for a motion to suspend the constitutional 3-day rule.
Move to suspend constitutional 3-day rule.
Senator Perry moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell, Cook, Creighton,
Be
Eckhart.
28 ayes and 0 nays. Rules are suspended. Chair lays out on third reading, final passage. Committee substitute for Senate Bill 13. The Secretary will read the caption.
Committee substitute, Senate Bill 13, relating to the provision by political subdivision of credits against impact fees to builders and developers for certain water conservation and reuse projects.
Senator Perry, you're recognized for a motion.
Move final passage.
Senator Perry moves final passage. Committee substitute for Senate Bill 13. The Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell, Cook.
28 ayes, 0 nays. Bill is finally passed. Congratulations. Senator Parker, you're recognized for motion to suspend the regular order of business and the printing rule on Senate Bill 10.
Thank you, Mr. President. I'm going to suspend the Senate's regular order of business to take up and consider SB 10, along with suspending the printing rule. In Texas, survivors of human trafficking are still being convicted for crimes their traffickers compelled them to commit. Current duress law only applies when there's an immediate threat of death or serious bodily injury. While that's appropriate in most cases, it fails to account for the prolonged and complex exploitation trafficking victims endure. By definition, traffickers use force, fraud, and coercion to maintain control. This includes psychological, financial, and emotional manipulation, withholding identification, creating dependency, or making false promises of safety, jobs, or legal assistance. These tactics don't always involve immediate physical violence, meaning many victims are denied the ability to claim duress and are wrongfully criminalized. Senate Bill 10 members establishes an affirmative defense for survivors who can show they committed an offense because of force, fraud, or coercion. This allows survivors to tell their story directly to the jury without having to prove their trafficker was charged, only that their actions were the direct result of exploitation. The bill does not apply to 3G offenses, where the traditional duress standard remains necessary due to the severity of those crimes. I believe most prosecutors would never knowingly bring charges against someone forced to act by a trafficker. But all too often, victims are prosecuted simply because law enforcement and prosecutors aren't fully aware of all the nuances of trafficking. Members, therefore, Senate Bill 10 both modernizes our duress laws and serves as an educational tool for the justice system, aligning Texas law with the realities that survivors are facing. This bill ensures that our justice system protects victims instead of perpetuating their victimization. Mr. President, I move suspension.
Senator Parker moves suspension of the regular order of business and the printing rule on Senate Bill 10. Is there objection? Hearing none, rules are suspended. Chair lays out on second reading Senate Bill 10. Secretary will read the caption.
Senate Bill 10, relating to an affirmative defense to prosecution for certain victims of trafficking of persons or compelling prostitution.
Senator Parker, you're recognized for a motion.
Mr. President, I move passage to engrossment.
Senator Parker moves passage to engrossment. Is there objection? Hearing none, bill is passed to engrossment. Senator Parker, you're recognized for a motion to suspend the constitutional 3-day rule.
Mr. President, move to suspend the 3-day rule.
Senator Parker moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell.
28 ayes, 0 nays. Rule is suspended. Chair lays out on third reading. Final passage. Senate Bill 10. The Secretary will read the caption.
Senate Bill 10, relating to an affirmative defense to prosecution for certain victims of trafficking of persons or compelling prostitution.
Senator Parker, you're recognized for a motion.
Well, first of all, thank you, Mr. President, members, for your great support. It's so important that we give victims of human trafficking the tools they need to be successful, to be able to live a normal life, and to break free of this coercion and force that occurred and so often in these various cases. This is an important tool in the fight against human trafficking to ultimately eradicate it. And with that, Mr. President, I move final passage.
Senator Parker moves final passage of Senate Bill 10. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell.
28 ayes and 0 nays. Bill is finally passed. Congratulations.
Thank you, Mr. President, members.
Senator Hughes, you're recognized for a motion to suspend the regular order of business and the printing rules on Senate Bill 16.
Thank you, Mr. President. I move to suspend the Senate's regular order of business and the printing rule to take up and consider at this time Senate Bill 16. Senators, this is the Omnibus Courts Bill. You'll recall that every session there's legislation to create new courts, to adjust the jurisdiction of existing courts, to handle administrative matters, and some judicial policy matters as well. And so that bill passed that was House Bill, Senate Bill 2878 in the regular session. There was a policy matter added late in the process that was of a concern to the governor. So the governor vetoed that bill and asked us to come back and remove that policy area. The bill before you removes the offending provision that the governor had concerns about. Also, a couple other differences. In Senate Bill 2878, we had a number of judicial bills that were standalone bills and also included in 2878. Now that we know a number of those bills have passed on their own, we've removed them from this draft. Also, another request or two from the governor's office, from members of the legislature for judicial administrative matters. And that's what the bill does. And I will, should the Senate see fit to suspend, I'll have a floor amendment to correct a drafting error. That's what the bill does, and I move suspension of the regular order of business and the printing rule.
Senator Hughes moves suspension of the regular order of business and the printing rule on Senate Bill 16. Is there objection? Hearing none, the rules are suspended. Chair lays out on second reading. Senate Bill 16, the Secretary will read the caption.
Senate Bill 16, relating to the operation and administration of and practices and procedures related to proceedings in the judicial branch of state government.
Following amendment. Secretary will read the amendment.
Floor Amendment number 1 by Hughes.
Senator Hughes, you're recognized on the amendment.
Thank you, Mr. President. Senators, floor amendment number 1 is that drafting error correction that I mentioned on my motion to suspend. In House Bill 2878, the Omnibus Courts Bill, this full provision was included, and somehow when we got the draft of this version, the language before you was inadvertently removed. It was supposed to be there. It's good policy. And we already voted for this in the Omnibus Courts Bill in the regular session. And so I move adoption of Amendment 1.
Questions on the adoption of floor amendment number 1? Is there any objection? Hearing none, amendment's adopted. Senator Hughes, you recognize for a motion.
I move passage to engrossment.
Senator Hughes moves passage to engrossment. Is there objection? Hearing none, the bill is passed to engrossment. Senator Hughes, you recognize for a motion to suspend the constitutional 3-day rule.
I move to suspend the constitutional rule. The bills be read on 3 several days.
Senator Hughes moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco,
28
Campbell.
ayes, 0 nays. Rule is suspended. Chair lays out on third reading. Final passage, Senate Bill 16. The Secretary will read the caption.
Senate Bill 16, relating to the operation and administration of and practices and procedures related to proceedings in the judicial branch of state government.
Senator Hughes, you're recognized for a motion.
Mr. President, I move final passage.
Senator Hughes moves final passage. Senate Bill 16. The Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell.
28 ayes, 0 nays. Bill is finally passed. Congratulations.
Thank you, Mr. President. Thank you, Senators.
Chair lays out on second reading Senate Bill 8. The Secretary will read the caption.
Senate Bill 8, relating to public school accountability and transparency.
Chair recognizes Senator Bettencourt to explain the bill.
Thank you, Mr. President and members. What gets measured gets fixed. And I think that's the perfect summary of Senate Bill 8 that will eliminate the STAAR test and ensure that Texas A through F school accountability system shows how school districts and campus are performing to students, to teachers, to parents, to really everyone in the state of Texas. SB 8 creates an instructional support assessment program and adds a transparency and clarity to the process that measures student success in our public schools. During 2017, the 85th legislature, this body passed HB 22, which established the current A through F system in our public schools. In 2021, I authored and we passed Senate Bill 1365 to address a third Court of Appeals ruling to ensure the continued operation of the accountability system. And since the passage of HB 22, we've been only able to release one single year, 2019, these important scores for the public for both schools and ISDs. For the past 2 years, the ratings have been intentionally blocked by repetitive taxpayer-funded ISD litigation. The first suit had 100 school districts in it. The second one was 30. The lead plaintiff, Kingsland ISD, however, was scored an F on these reports for their accountability ratings. So in July 3rd of this year, and then recently, the 15th Court of Appeals has ruled against these blocking lawsuits and release of A through F ratings, both in both lawsuits. And so today we're going to continue the work from a really good bipartisan conference committee report that was drafted with Chairman Buckley from the House and some really good work that was done at the end of the session. We're going to replace the STAAR test with 3 shorter assessments at the beginning of the year, the middle of the year, and the end of the year, starting in the 2027-28 school district, the school year. We're going to implement adaptive level tests for the beginning of the year and the middle of the year assessments to provide individually actionable results that are specifically tailored to each individual student. And a summary criterion reference assessment based in Texas TEAGs and standards at the end of the year for the end of year assessment. I think this idea of having members having these first 2 tests that will have their results within 48 hours back to the students and to the teachers is so important. So we'll get out of teaching to the test and actually understanding what the knowledge base of individual students are in detail, because these item level tests are incredibly useful in diagnostics of learning. We're going to guarantee the annual results release of A through F. We're codifying the continued commitment to continuously improving student success by establishing an accountability refresh system every 5 years that will enable the commissioner to increase standards or change indicators outside of the schedule when needed. We're going to ensure predictability of the accounting system by requiring advance notice of changes to standards or indicators, provide a model on how districts and campuses would perform under those changes, and establishing clear deadline on publishing expectations. And if the deadlines are not met, the accountability ratings will be based on the prior year expectation. Couple more points. Promote post-secondary readiness and success by aligning and weighing college, career, and military readiness indicators as they correlate to real-world outcomes such as wage attainment and career opportunities. And I really think that's going to be a big boost for those obvious next steps for people leaving the public education system but headed into college, career, and military readiness. Support local accountability initiatives by establishing a grant panel to help districts equate local accountability plans into account in their unique indicators of student achievement. So bottom line is, what gets measured gets fixed. Texas parents deserve to know how their schools are doing, students are doing, and how taxpayers deserve an end to endless lawsuits. The bottom line is that this will be a much fairer way, ending the 1 STAAR test, stress test at the end of the year, and providing 3 tests in a year and help student knowledge what I hope for decades to come. And with that, Mr. President, I move, let's see, I guess you're going to recognize me for passage of third reading?
Senator Kokos, for what purpose?
To ask the author some questions.
Do you yield, Senator Bettencourt?
Certainly.
Senator Bettencourt, this is very similar, as you said, to House Bill 3. Was it 3?
Back in the regular session. Right. In fact, House Bill 8 and Senate Bill 8 were filed identically by both Chairman Buckley and myself, and as heard in the Education Committee by Senator Creighton.
So I know we got to conference committee, we had signatures, it kind of blew up at the end. Could you tell me, this is the exact bill from conference?
Well, there are some improvements, but to go back to we had 5 signatures, bipartisan signatures on the floor for the conference committee report. And for example, I've got a couple technical amendments to make on a cleanup. So we're always improving the bill, but I'm really excited about this bill because the more we lay it out, the better it gets. And I think we're at a point where it's going to be a really transformational bill for education in the state.
So for years, serving here and the honor of serving here and the voters allowing me to come back and represent their voices, I have heard from parents, teachers, of course, students never like to be tested, but the parents and the teachers that STAAR at the end of the year is a one-size-fits-all and is not really a measure of a child's improvement. Would you agree?
Absolutely. And that's why this bill is transformative. Because think of it. Instead of everybody teaching to the STAAR test and it's a winner-take-all effectively, there's all sorts of euphemisms for it. We're going to start off the year and give a beginning of the year test. And these adaptive level tests, if the more you answer right, the more the questions they give you. If you answer wrong, it kind of keys in and looks for what are you missing. And they're going to be feedback like that. And within 48 hours. And then we're going to do it in the middle of the year. So we're going to look at where the students start, and we're going to look at where they are in the middle. And that's what we should be doing. Testing shouldn't be just a end-of-year horror show, for lack of a better description.
Right, so stay with me on that, because some students, and obviously different intellect levels, different environments that a child progresses over their tenure of K through 12, and then into either training on a trade or into college. This is going to be something that measures how the child is progressing, not this mold that we're trying to pour them into. So a teacher could take a child who is testing down here, mid-year move them to here, and by the end of the year move them to here.
Advance them more than one.
Maybe more victorious, and we should be triumphant in that than the child that started the year up here and finishes up here, right? Because we're progressing.
Right, and that's part of the accountability system is how much you improve students. But this is a diagnostic tool that lets you see it. Now, not us. I mean, as much as
lawmakers don't need to see it,
right? It's the teacher and the student. They can see it within 48 hours. And so I think this is an astonishingly transformative way to change all of this.
Well, the reason I'm asking these questions, I'm not on education. I have served a term on education, but here's what's really important, because this bill came so late in the session, and we had so many big bills moving. You had HB 2, SB.
Pick a number.
Man, there were a bunch of them, okay? And then this one kind of floated through. Nobody really said anything. This has been the number one issue throughout all my years in the House and the Senate of parents and teachers saying the end of the year test, where there's this high pressure test that is a one size fits all, was really in many ways made for people to fail. This is going to be a diagnostic tool that gives teachers the immediate feedback and allows the school districts to hone in on where a child is really missing. And it will go year to year. Is that correct?
That's correct. For each specific grade level that goes year by year up the ladder. Let me give you one thing that you'll love. We took some testimony because part of it is right now with the current STAAR test, basically things are frozen the last week. You can't do any learning. Everybody kind of ties down and starts teaching to the test. Well, you don't have to do this now. And we did a quick calculation with the commissioner there and some of the witnesses. And if you take, an average of 22 and a half hours of instruction time times 4.1 million kids that will be taking this, that's 92 million instructional hours that are freed up because they're not frozen in advance of the final test. No, this is going to be really transformative.
The word I was going to use was transformative. I know we'll have to go through a lot of iterations to get it right, but here is the thing. Is the message, can I go back home and say to teachers and to superintendents and to administrators and principals, most importantly to parents who are guiding their children, that we now have a test that is not just a high stakes end of the year test. It is one that measures where you start,
right,
which will give us a measure of what we retained over the summer.
Check.
Middle, hey, we're doing pretty good with this child, or wow, something's going on here. We're not making any progress, or we've somehow taken a step back. And then the end of the year, which I think have been talking about in this building for 20 years.
Well, we're going to do it at least from a unicameral legislator's viewpoint right now. But more importantly, the House will catch up because I think it's a super compelling idea. But yes, we're going to do it. And I'm really excited about it.
Well, thank you. Thank you for taking my questions because truly, during session, again, this kind of came through with, because of so many bills with very little fanfare. And I'm going to tell you something, Senator Bettencourt, of all the school issues, funding, obviously, with superintendents is always number one. But when it really comes to parents and teachers, the STAAR test, the end of the year high pressure test has been the feedback I've received the most consistently through these years.
Right, negative flashpoint that people see in the system.
Thank you.
So
thank you for this bill. Look forward to getting it over the finish line.
Signing on too as well.
Any other questions? We're going to go to engrossment. Amendments, excuse me. Following amendment. Secretary will read the amendment.
Floor amendment number 1 by Bettencourt.
Senator Bettencourt, you recognize on your amendment.
Thank you, Mr. President. As I mentioned, this amendment it cleans up technical errors in the bill. In the development of the legislation, we proposed a new requirement the standard be adopted on July 15th to make sure there was no changes in any type of standard released to the public. This error required that retroactively, so we changed that one. There was a drafting error that repealed the provisions that allowed the Texas Success Initiative assessments to be substituted, and that needs to be fixed. And then finally, the amendment added clarity on prohibition of benchmark testing to make sure that the state assessments are not affected. I move adoption.
Any objection? Hearing none. Amendment is adopted. The following amendment. Secretary will read the amendment.
Floor amendment number 2 by Bettencourt.
And
Senator
members, sorry. Thank you, Mr. President and members. Just to make sure everyone knows that we do listen in the Education Committee under the able chairmanship of Chairman Creighton. The Texas Disability Rights Organization came and they had spotted a problem with waivers. So we added removed the section that was added as apparently a floor amendment in the House that directed the Commissioner of TA to request waivers for federal accountability requirements for special education students. Public testimony from the Disability Rights group in Texas highlighted the concern that a blanket request for special education campuses would open the door for lower expectations, and we agree. So I move adoption.
Any objection? Hearing none. Amendment is adopted. You recognize passage to engrossment.
Thank you, Mr. President. And move passage to engrossment of Senate Bill 8.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell.
22 ayes and 6 nays. The bill passed to engrossment. If you can find a few friends.
He's got it.
Oh, you have it. You can suspend the constitutional 3-day rule.
So moved, Mr. President.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco.
23 ayes, 6 nays, 1 absent. The rule is suspended. Chair lays out third reading and final passage. Senate Bill 8. Secretary, read the caption.
Senate Bill 8, relating to public school accountability and transparency.
You're recognized on final passage.
Thank you, Mr. President. With hope of a transformational bill for all of education and the replacement of the STAAR test, I move final passage of Senate Bill 8.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell.
You might call this the STAAR test for the members. They've passed it now twice, or at least most of them have. 22 ayes, 6 nays, 2 absent. The bill's finally passed. Thank you.
Thank you, Mr. President. I'll remember that one.
I'm not so sure everyone could pass the STAAR test. Senator Parker. Members, we're getting ready to go back to business here. Chair recognizes Dean of the Senate for a motion.
Thank you, Mr. President. I move that the Senate recess until 10 a.m. Friday, August 15th.
Any objection? Chair hears none. The Senate stands in recess until 10 a.m. Friday, August 15th. Everyone, please be on time. 10 o'clock, we'll be on time. I'll be on time. We'll all be on time at 10 o'clock. All right, thank you.
The Texas Senate has concluded its deliberations for the day. Please join us on this same channel live for the next meeting of the Texas Senate.